Yes.
So on the last occasion, Lordship was pleased to give us the liberty to make a mention of item number 42. If we want to do it earlier or later, then Lordship may accommodate. So my humble submission, either Lordship may be pleased to take up at the beginning or after 3:30.
Fine.
Both item 40 and 42. 40, the same councils are there, Lord.
3:30.
3:30. Highly obliged. Lordship.
Mr. Das,
Fine.
any?
No problem. No.
3:30. Priority material.
Highly obliged, Lordship.
May please, Your Lordship. My lord, I beg to mention for the
All
listing of the
listing
matter.
matters, give it to them.
Lordship, with regard to item number 32, Lordship, petitioner is claiming compassionate appointment, Lordship. His father had passed away while in service. Lordship, in this case, Lordship, while the petition was filed, the scheme of the compassionate appointment was not filed along with the petition. So
Consider it.
we need some.
Oh, that scheme is not
Yes.
the bank.
Do we need some time, Lordship, weeks time
Okay.
to file additional
Okay.
affidavit?
Mr. A. Ganguly, have you taken the consent of the other side?
No, I could not get through his.
Okay. Let the matter which will accommodate. If he does not have the scheme, we'll accommodate. Yes.
May I please look?
2019, the death.
Scheme I have, Lordship.
No, death is 2019. They say that you have the requisite financial resources.
Yes.
Wilson.
May I please, Lordship? Lordship, I beg to mention item number 44, Lordship. In this item, Lordship, I have filed the affidavit in reply. We are for respondent, petitioner, Lordship. Affidavit in reply.
Get it.
Yes, we are maybe allowed to call from the section, Lordship.
Oh.
Yes, I love it.
Beg to mention item number 14. Your Lordship, one analogous matter is also pending.
Item number?
14, 1 4.
Hmm.
One similar matter is also pending hearing number WPC 2498 of 2025. Lordship, may kindly list both the matters on the same date.
You are the arguing counsel or somebody?
For the petitioner.
Who is the arguing counsel?
Or
Who will do the case? Will you do the case? Will you argue the case? Then who is arguing the case?
DJ Boro is.
Get him. Get him.
May it please, Your Lordship. Lordship, may I please to mention item number 58, supplementary list, my lord, hearing item. Lordship, can it be adjourned, Lordship? I have some personal difficulties today, my lord. Item 58.
Huh?
Item 58, Lordship, supplementary list, hearing matter.
Why? Gampura, this is a settled matter now.
Lordship, just 2 weeks, my lord. I am unable
Why?
to prepare for
18
today, my
matter.
lord.
Why?
I am unable to prepare this case today, my lord.
Mr. Das is prepared, expert, Gampura.
Lordship, 1 or 2 weeks, my lord.
This issue is already resolved by this court.
Lordship, otherwise there is an order of this honorable court to
Lordship,
submit court fees as well.
In this case, Lordship, we have challenged the clause 7 of the OM, Lordship. The issue is different, Lordship. Wherein,
On the
Lordship,
prayer of
the
Mr.
second-
R. Karim, learned counsel, Mr. R. Karim, learned counsel for the petitioner submits that he be granted 2 weeks' time to submit the court fee with regard to the court fee as directed by this court for the total number of petitioners joining together in the present petition. Also, by accepted, the court fee be submitted on or before Five 8/2026. Registry to list this matter again on 12/8/2026 for hearing.
Obliged.
May I please, Lordship? In item number 39,
Huh?
in item number 39, I am paying for adjournment, Lordship.
Right.
On last Monday, the respondent filed their affidavit in opposition. We would
Your
like to
name?
file our reply.
Your name?
N. Thakuria for S. Sharma, Lordship.
Mr. N. Thakuria, learned counsel, appearing for Mr. S. Sharma, learned counsel for the petitioner, prays that he be granted
3 weeks.
3 weeks' time to file a rejoinder to the affidavit filed by the respondents. Pray accepted. Registry to list this matter again after 3 weeks on a date to be
What
fixed.
date may be fixed? And
May I please, Your Lordship? I beg to mention item 34 in the daily list. An adjournment slip has been passed to this effect. We await signed affidavits to file. It's
Signed
en route.
affidavit of,
Respondents.
you are appearing for,
For the respondent, AAU.
Mr.
S. Sharma.
S. Sharma, learned counsel, appearing for the Assam Agriculture Unit University, submits that he be granted how much?
Well, that's any 2 weeks.
2 weeks further time to file an affidavit on behalf of the respondents represented by him. Mr. Sharma undertakes that before the next date of listing, the affidavit would be invariably brought on record. So, in view of the above, the present petition stands disposed of, stands adjourned for 2 weeks. Registry to list this matter again after 2 weeks on a date to be fixed by.
Obliged.
May please your lordship, I beg to mention item number 53. The conducting counsel, Mr. B. Pathak, is out of station, lordship.
A prayer is made on behalf of Mr. B. Pathak for an accommodation in the matter on the ground that he is out of station. Pray accepted. The registry to list this matter again after 3 weeks on a date to be fixed.
May I please your lordship, I beg to mention item number 54 of the supplementary list, lordship. Kindly matter may be adjourned for a week, lordship. I have taken the consent. lordship.
You are appearing for?
Appearing on behalf of Mr. T. J. Monto for FPSC, lordship. Respondent number 2, 3, 4, and 6.
This is a panchayat matter.
No, no, that's it. This is
Some
the
3,000
examination.
costs was given where? Here only?
No, no.
Next matter. Okay. A prayer is made on behalf, why you want an on?
Lordship, they have filed an affidavit, lordship. In this regard, we need to take instruction, lordship.
Miss
PP dash, lordship.
PP Das, learned counsel appearing for the APSC respondent submits that she be granted
Lordship, 1 week.
1 week time to complete instructions with regard to the rejoinder affidavit filed by
No,
the
additional.
Additional.
affidavit filed by the petitioner. Mr. A. Gautam, learned counsel for the petitioner, does not object to such prayer made on behalf of the respondents. So accordingly, the matter stands adjourned. Registry to list this matter again on 5/8/2026.
Obliged, lordship.
Grateful.
Yes.
May I please, your lordship, I beg to mention item number 41. Lordship, may allow me to withdraw it to liberty to file afresh. I have annexed a notification which is not relevant to the case, lordship. So I have to file it fresh.
That NCL
OBC
certificate,
issue.
NCL certificate, 2024-25.
24, 20. There is a
Mr.
notification.
R. Bora, learned counsel for the petitioner, submits that he be permitted to withdraw the present petition with the liberty to file the same with the relevant documents. Prayer is not objected to by the learned counsel for the respondents. So accordingly, the present petition stands dismissed with liberty as prayed for.
That's a nice.
May I please your lordship? Lordship, I beg to mention item number 50, lordship. I am praying for adjournment, lordship.
This matter, your lordship, I am the petitioner. Mr. Kyle informed me that they would like to file an additional, I think, reply. But since the
It
matter
is
is.
that posting within some.
Yes,
quality.
it's a posting without giving a posting.
Expose. You were some officer, now you are made a research officer.
Yes, that post was.
Your salaries are, there is a contempt.
Salaries were paid,
But now it is stopped.
no, it has been stopped, but ultimately by the interim order of the Honorable Court.
So
was
this
paid.
contempt petition was only with.
Only with regard to non-payment of.
So whether that survives, violation
That basically,
is not required to be considered.
lordship may take it up because.
Yeah,
since-
okay, item 50 and 51. On the prayer of the learned counsel for the respondent number 2 and 4. The matter stands adjourned to facilitate the said respondents to bring on record further pleadings. Prayer is not objected, Mr. Y, Mr. Y.S. Manna, learned counsel for the petitioner is present. In view of the above, the matter stands adjourned today. The registry to list this matter again after
10 days, lordship.
Lordship.
on 10/8/20.
Since it is a hearing matter, maybe a hearing day.
11/8/2026.
Obliged.
Lord, with regard to that matter, lordship, I could get through him, lordship.
Hmm.
He has given his consent, lordship.
Okay.
Item number 32.
Okay. Item number,
32.
Mr. A. Ganguly, learned counsel for the petition, submits that he be granted 2 weeks' time to furnish the policy, the scheme with regard to appointment on compassionate grounds framed by the respondent bank. Also, pray accepted, registry to list this matter again after 2 weeks on a date to be fixed by. Yes,
Hello.
ma'am.
May it please the Lordship, I beg to mention item number 46. An adjournment slip has been circulated
You are appearing for?
for the petitioner on behalf of H.K. Das.
A prayer is made on behalf of the learned
Lord, may
counsel.
give us to
For learned counsel for the petitioner for an adjournment in the matter to file a rejoinder. File a rejoinder.
file an affidavit in reply.
To file a rejoinder to the affidavit filed by the respondents. Also, prayer accepted, a registry to list this matter again on 12/8/2026. Interim order passed earlier to continue till the next date of listing. Transfer matter, we will not give you further time. None appears for the petition on file. The present contempt petition has been instituted alleging violation of the directions passed by this court-wide order dated 9/3/2026 in WPC number 1228/2025. Issue notice returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents by way of registered, by way of speed post, steps within 3 working days from today. Also, personal appearance of the respondents, dispense with for the time. At this stage, dispense with that. Yes.
For item 7 and 8, Lordship.
Huh?
For item 7.
Seven. What is your name?
Lordship D. Borua.
D. Borua.
On behalf of the
There, there's a petition.
seven.
Huh? Mr. D. Borua.
And item 8 also.
Item 8. Yes, what is this?
Lordship, kindly pass over the matter for the time being.
Why in the morning itself pass over?
Because already passed over.
Where is the order dismissing the other claims, other writ petitions?
8.
Okay, you get it after some time.
Under a non-consideration of my case for promotion to the next higher career.
But
The earlier occasion they for time.
Yes.
I have received the paravise just in the morning. I haven't gone through that.
What happened to the departmental proceeding?
Still continuing.
What happened to your departmental proceeding, Mr. Mehta?
My lord, the inquiry report has not been served upon me, madam.
Okay, so that is pending.
Pending, madam.
So if that is pending, have they resorted to, because this proceeding was instituted sometime in promotions were after your
Yes, madam.
after your DP. So have they kept your case in seal cover?
No, madam.
Yes, Mr. Is the
Okay,
case
but-
kept in seal cover?
Which will have to go through the instructions.
Just go through it and tell me. We'll take it up after some time.
May I please.
Who is appearing for the respondents? BHC. Why these days there is no representation of, no standing counsel these days? After some time.
My lord, they need to have filed the instruction, my lord, why they have not been
If they
given.
are not here, we'll go with the materials available. We have given them an opportunity. We'll dispose of the repeat. Let them see. Next round we'll call it. Yes, Mr. Bora.
Yes, my lord.
Any order?
My lord, so there is an, my lord, communication from the, on the basis of your lordship, that order regarding the status of the vacancy, my lord. So this is a communication by the superintendent to the DSS, my lord, now direct.
Mr. DP Bora. in terms of the orders, directions passed by this.
Now, my lord, the
order,
Director of Health Services written to the government for their approval because
with regard to the directions passed by this court-wide order dated 16/7/20 has submitted that the superintendent in Gauhati Medical College and Hospital provide a communication dated 17/7/2026 has informed the Director of Health Services Assam that there is a post of matron presently available in the said hospital against which the petitioner can be accommodated on her promotion. It is further projected in the said letter that the hospital authorities have got no objection in the event the permanently listed as matron in Gauhati Medical College. Mr. Bora submits that in view of the said development, on the approval being received to the proposal for promotion of the matron in DMCH, necessary orders in this connection filed passed would be issued by the Director of Health Service, and for the matter, he submits that he be granted 2 weeks' time. So accordingly, registry to list this matter again on 12/8/2026, on which date the Bora shall place on record orders issued towards promoting the petition, towards posting the petitioner as matron in GMCH in violation of earlier orders issued in connection. Also, the interim directions passed by this court earlier to continue till the next date.
I'm deeply obliged.
Obliged, my lord.
CP4.
He cannot determine red and green color.
Huh?
Red and green color he cannot determine.
Yes.
Lordship, the initial DME, Lordship, it rejected and then
Forget what has happened. Now come to page 44. This is the report of the review medical board.
Lordship.
Now the review medical board has held you
Yes,
to
Lordship.
be unfit because of this CP4.
CP4 law.
Then what is left?
Lordship,
Can
look,
we sit over this? What is the irregularity in this?
No, I'm not challenging the irregularity basically, but then the DME specifically states that a specialist opinion has to be brought.
Specialist opinion. has
He
to be-
brought a specialist opinion.
No, there is 3 specialists here in this review medical board. Have you alleged malafide against them, bias against them?
No, I have not alleged that. But then there may be an error, Lordship, in
We
judgment.
can't say that. Why should we go to that extent?
But thereafter, Lordship, he has appeared, he has gone to Gauhati Medical College always.
Whether you have gone, somebody else has gone, we don't know. But we have the report of the review medical board consisting of 3 ophthalmologists. And their report is enough for.
Lordship, may I pray in another manner, like there is a notification of staff selection commission wherein it says that CP4
After the
is-
review medical board, after the review medical board.
I'm not on that, Lordship. The notification says that CP4, a candidate having CP4 can be appointed in another.
We'll
TFP
not permit that. Where is that?
Nowadays all are computer
That Lordship, page 46, Lordship, if your Lordship comes to.
Page 50 is the.
Lordship, page 50. My apologies, Lordship. Page 50,
Clause?
clause 6D, Lordship.
Okay.
The last line, this standard is permissible for various tradesmen's categories of jobs in CAPFs and Assam Rifles, Lordship.
Okay, where is that? You should be given in some other.
Lordship, it only says, right?
This is of 2012, my lord. I don't know, my lord.
It's still on force, Lordship.
Heard Mr. D. Deka, Learned Counsel for the petition. So heard Mr. K. Parasa.
K.K. Parasa.
is the appearing, huh?
KK Paras.
K. Parasa, Learned, the appearing for the respondents. Mr. Parasa submits that before issuance of notice the matter, this court would be pleased to grant him a week's time to complete his instruction. I accepted. Registry to list this matter again on 31/7/2026. The Parasa in the meanwhile, complete his instructions. Take an instruction how they have considered his that Gauhati Medical College report. That much.
Mal.
Highly obliged, Lordship.
Yes.
Lordship, I will be only doing the matter.
You do the matter.
The petitioner was an assistant commandant of the first Assam Special Reserve Force, Battalion Borjhar Nalbari, Assam on 26/1992. And thereafter he served the Department of the Civil Defense and the Home Guards, Assam.
Yes, madam.
Petitioner was also serving from severe diseases such as serious cardiac and neurological ailments since 2010 and had undergone coronary artery bypass graft surgery in 2011 and was medically advised complete rest in August 2024. Accordingly, he applied for commuted leave on medical grounds, which was granted from time to time. During the period of this medical leave, petitioner submitted an application seeking voluntary retirement on medical grounds with effect from 1/10/2024. While the petitioner was still undergoing medical treatment and availing medical leave, the respondent authorities by order number HMB 564374 of 28 dated 21/2025 placed him under suspension under Rule 6 Clause 1 of the Assam Service Discipline and Appeal Rules 1964. However, prior to his retirement, neither in his search sheet, memorandum searches, statement of allegations, nor in his so-called notice was issued nor served upon the petitioner. Petitioner therefore attained the age of superannuation and retired from his services. On 31/1/2025. Despite the
31/1/2025.
petitioner has neither been paid any pensionary benefits, including provisional pension, causing financial hardship and violations of the provision of the Assam Service Pension Rules 1969. And we have filed this WPC to challenge the impugned so-called notice dated 25/3/2026, seeking to initiate and continue a Department of Proceeding. So-called notice issued on 25/3/2026 in order to initiate a Department of Proceeding against the petitioner, and we are filing this WPC challenging that so-called.
What is the ground for challenge? Your ground is in para 15. Okay. Yes.
Notice me issue because.
Why?
Because his suspension order is not before your lordship.
Okay.
Suspension.
Suspension order died its natural death on his retirement on 31/1.
Before that suspension order was issued, that was not annexed here, my lord.
No need.
Pending departmental proceeding may be suspended. Then departmental proceeding started.
Fine. When did you start the departmental proceeding? 25/3/2026.
That's why, my lord, suspension order not before your lordship. So I cannot say. What is the
Suspension order is not required, Mr. Chutia. He retired on 31/1/2025. The suspension order died its natural death. Now that he is retired on 25/3/2026, how could you institute a proceeding under Rule 9? You should have instituted a proceeding under Rule 21 of the pension rules.
That is, my lord, maybe technically, my lord.
It's apparent on the face of it.
My lord, so far that suspension order is there before retirement.
You get your instructions.
Yes, I will get
them.
But before that, my lord, suspension order was issued before retirement.
Miss.
One more WPC also pending.
For what?
That is for pension matter should be.
For pension.
Yes.
You are being given a provisional pension. Have you been given a provisional pension? Madam,
Yes.
have you been given a provisional pension?
idea of the picture.
Need to look into it, Your Lordship.
Okay, Lekha. Your name?
Please, Soikia.
Ms. C. Soikia, heard Ms. C. Soikia, learned counsel for the petition. Also heard Mr. T. Chutia, learned C. Additional Senior Government Advocate, assisted by Mr. H. Prabhu, learned Government Advocate, appearing for the state respondents. The petitioner by project has presented a challenge in the present petition to a show cause notice dated 25/3/2026, instituting a departmental proceeding against the petitioner by invoking the provisions of Rule 9 of the Assam Services bracket Discipline and Appeal bracket over Rules, 1964. It is projected in the writ petition that the petitioner on reaching the age of superannuation had retired from his services with effect from 31/1/2025. However, it is also projected that the petitioner was placed under suspension with effect from 21/2025. The petitioner issued notice returnable 4 weeks. Mr. A. Chakraborty, learned counsel as government advocate, assisting Mr. T.C. Sutia, accepts notice on behalf of all the respondents. No formal notice, except the prayer for interim relief. The learned counsel for the parties have been heard on the prayer for interim relief made by the petitioner. As noticed herein above, the petitioner had superannuated from his services on 31/1/2025. Thereafter, the petitioner cannot be deemed to be a government servant. Discipline. A perusal of the provisions of Rule 9 would go to reveal that the same is permissible to be so invoked for drawing up a departmental proceeding against a government servant. The petitioner, after his superannuation, cannot be deemed to be a government servant any further. Accordingly, a departmental proceeding against the petitioner would be permissible to be so instituted only by invoking the provisions of Rule 21. Rule 21 of the Assam Services bracket Pension Rules 1969. So, in view of the above position, this court is of the considered view that in view of the above position, the show cause notice dated 25/3/2026 issued to the petitioner shall remain stayed till the next returnable date. The respondents are granted liberty to revoke the order dated, show cause notice dated 25/3/2026 and issue fresh show cause notice to the petitioner, invoking the provisions of Rule 21 of the said rules of 1969, if so permissible in law. Registered to list this matter after 4 weeks on a date to be fixed. Mr. Chutia, you can advise your clients that because 4 years thing crossing, you will not be able to.
Yes.
That's why I have given you the liberty.
Deeply obliged, my lord. She will provide my extra copy, my lord.
Madam, extra copies.
But petitioner retired in the year 2018, my lord.
Yes, Mr. Chakraborty.
Lordship, he has not.
Apparently, don't find anything against.
Lordship, in the representation, Lordship, he has stated that due to the, I am unable to submit documents pertaining to retirement benefits in time, Lordship.
In time means he might have submitted.
Lordship, and now I am quite stable, but I have lost many documents.
You get your instructions.
Lordship, will obtain instruction.
But Mr. K.R. Padgiri, learned counsel for the petition, also heard Mr. A. Chakraborty, Government advocate appearing for the respondents.
Respondents,
Mr.
1, 2,
Mr. Padgiri has submitted that the petitioner had retired from, petitioner who was a member of the Assam Civil Service had retired from his service on reaching the age of superannuation with effect from 30/6/2018. Thereafter, his pension and pensionary benefits have not been finalized and disbursed to him. Mr. Chakraborty submits that, Chakraborty, learned government advocate, submits that he be granted time till 10/8/2026, complete his instructions in the accordingly, registry to list this matter again on 10/8, on which date Mr. Chakraborty, on completion of his instruction, authorized this court by a delay is occasioning, authorizing a petition, pension and pension.
I have for S1 number 6.
Mr. R. Boro, learned standing counsel, accountant general, Assam is present.
Pendency shall not be a provisional pension, my lord.
Provisional pension also not given. In the event, it is further provided that even a registry to, that in the event the petitioner has not been authorized a provisional pension, the respondents before the next date of listing shall authorize to the a provisional pension, if there is no further impediment.
Obliged.
You are appearing for?
I'm appearing for NCMs.
Yes. Mr. Das.
Lordship.
Now, you have considered her white that order at page 26. What is the date of this order, Mr. Soikia?
15/9/2024 to 2005, my lord.
9. 20?
2005, my lord.
2005. Now, if you have considered her, this appointment as a candidate under the compassionate appointment scheme,
Lordship.
but you have already engaged her in such capacity earlier.
In the year 2001. Lordship.
How can that be?
Lordship, instructions I have received, but today morning on my way to the court, Lordship, it is in my phone. So may I pray that let this matter come up next week. In the meantime, I will file my affidavit, Lordship. Okay.
Mr. Ayat Saikya, learned counsel for the petitioner. Also heard Mr. R.M. Das, learned standing counsel, Bima Hasa Autonomous Council.
Lordship.
I'm appearing for respondent 1 and 2.
Also heard Mr.
P. Hazarika.
P. Hazarika, learned standing counsel, Soil Conservation Department, and Mr. R.M. Das,
3, 4, and 5.
standing counsel, Bima Hasa Autonomous. Mr. Das has submitted that he has received the necessary instructions in the matter and would file an affidavit on behalf of the Bima Hasa Autonomous Council authorities on or before 31/7/2026. So, registry to list this matter again on 5/8/2026 for motion along with the said affidavit. Highlight why the lady is to be troubled. Once you have appointed her on compassionate grounds, it cannot be ad hoc. It should be permanent. Either appoint or don't appoint.
Lordship.
Okay. Let him have that instructions. Mr. How many candidates had applied for this post?
Single candidate, my lord. Single candidate. In respect of.
Why did you hold this election then, if there was only one candidate?
Lordship, as per the Annexure 4, Lordship, So it is a reason for non-approval due to non-submission of valid mark sheet.
No.
Select candidate, Lordship.
It is, she is serial number 2, 3, and 4. What is this ground taken? Single candidate applied. Or is it your allegation that the Mr. Soikia was so powerful, he did not allow anybody else to apply?
That's an open
It
instruction.
was like a pocket tender.
Open instruction, Lordship.
Get your instructions by next week,
Next week, Lordship.
Wednesday.
On 10th, no. On 30, Lordship.
30.
30, Lordship.
Heard Mr. I.H. Soikia, learned counsel for the petitioner. Also heard Mr. H. Approval, learned
All the respondents.
appearing for the respondents. The petitioner in the present petition has raised the grievance with regard to the rejection of his candidature, with regard to the cancellation of the selection process, petitioners, selection process against the post of Anganwadi worker in helper in different Anganwadi centers by the Director Women and Child Development, Assam, on the ground that only one candidate against such Anganwadi centers had participated in the selection process. It is projected by Mr. Soikia that in pursuant to the advertisement issued, only the petitioners had submitted their respective candidature for the posts involved, and no other candidate had submitted such applications. It is submitted that the respondent authorities, with having knowledge of the said position, had proceeded with the selection process, and the same was taken to its logical conclusion. Also, and the same was concluded. Accordingly, he submits that only on ground that a single candidate had appeared in the selection process, the selection in question with regard to the post applied, a post against which the candidatures had submitted, against which the petitioners had submitted their candidature, did not mandate to be to be cancelled. Mr. A. Chakraborty submits that the matter be taken up on 3/8/2026, on which date he shall complete his instructions and apprise this court as to the basis for the decision arrived at in the matter by the Director, Women and Child Development. Accordingly, registry to list this matter again for motions on 3/8/2022. But Mr. M. Islam, that day I was to dispose. Then subsequently I got to know this is settled long back. And now he has come. So we'll issue a notice only.
Well, the recent order, my lord.
Where?
Page 74, my lord. This is a cover case, my lord. 26/2025.
Okay, we'll issue a notice, let him. Not that fresh case.
My lord.
We'll keep it for some time in the deep freezer so that it becomes
My lord.
fresh.
My lord.
Heard Mr. M. Islam, learned counsel. Also heard Mr. A.K. Ghosh. Also heard Mr. A.K. Ghosh, learned standing counsel, Panchayat and Rural Development. And Mr. Who is there for finance today? Also heard, just give one name, somebody.
Yes, sir.
Huh? A. Cholia, learned standing counsel, finance, and Mr. H. Prabhuti, learned government advocate. Issue notice returnable 4 weeks. Mr. Ghosh accepts notice on behalf of respondent number 1, 2, 4, 6, 4 and 6. While Mr. A. Cholia, learned standing counsel, Cholia accepts notice. And Mr. A. Chakraborty, A3 and 7, accepts notice on behalf of respondent number 5. As all the respondents are represented, no formal notice. So registry to list this matter again on 19/8/2026 for admissions.
My lord.
That day we'll dispose it.
My lord, along with my lord, the WPC number.
Along with forgetting. These are all individual matters.
Highly obliged, my lord. Obliged.
Mr. Gupta, at this stage, nothing can be done. We'll issue a notice only. Heard Mr. G.K. Gupta, Learned Counsel for the petition. Also heard Ms.
My lord, matter may be passed over for the time being.
Oh, we are issuing a notice, madam. You are appearing for whom?
We are on behalf of BK Singh.
He is here in the court.
Yes, on court.
Also heard Mr.
Yes,
B.K.
sir.
Singh, Learned Standing Counsel, FCI. The petitioner in the present writ petition has presented a challenge and order dated 31/10/2025 issued by his disciplinary authority imposing upon the petitioner penalty of dismissal from service. Also, issue notice returnable 4 weeks. Mr. B.K. Singh accepts notice on behalf of all the respondents. No formal note. Registry to list this matter again.
Can a date be given, sir? Yeah.
Please, your lordship. Lordship, I was working as an LDA in the office of the inspector of
Suspension?
Yes, lordship.
When?
As I was suspended on 26/9/2025, lordship. So far, there has been no departmental proceeding against me.
No, there is a show cause.
Yes, the lordship, there is a show cause and I have replied it, lordship.
So show cause is of
Show cause is of
26. Yes, madam. Beyond 3 months.
I'll take instruction, lordship.
Next day.
Notice may
Next week
issue.
we'll, no notice. Why waste time of the court? You have not instituted that within 3 months that will go. I'll give you a chance only. Get your instructions. But Mr. A.
Sarania.
A. Sarani, Learned Counsel for the petition. Also heard Ms. S. Sharma, Learned Standing Counsel,
All the respondents.
Health and Family Welfare Department. The petitioner in the present writ petition has presented a challenge to an order to the prolonged suspension occasioning in his case after being placed under suspension wide issuance of an order dated 26/9/2025. It is submitted that the said order of suspension was so issued invoking the provisions of Rule 6(2) of the Some Services (Discipline and Appeal) 1964 after the petitioner was placed under arrest in connection with ACB PS case number 51 of 20. It is projected that the petitioner was enlarged on bail on 3/11/2025 and had intimated the respondent authority said or of the said fact by a communication dated by a representation dated 3/11/20. It is further projected that a departmental proceeding in the matter was instituted against the petitioner only on 29/6/2026. That's beyond the 3 months period after the petitioner had intimated the authorities of the competent court granting enlarging him on bail in connection with the criminal against him. Also, Ms. S. Sharma, Learned Standing Counsel, Health and Family Welfare Department submits that she be granted a week's time to complete her instructions in the matter. Also, prayer accepted. Registry to list this matter again on 29/7/2026 for motions.
Lordship, extra copy today.
Oh, give him extra copy, miss.
My lord, the petitions number 3, 4, and 5. They're the contractual employees of the IOCL, my lord.
Are they contractual employees of the IOCL or are they contractual employees of the contractor of IOCL?
My lord, of the contractors.
So,
Yes,
if you are in a criminal case,
yes, my lord.
the contractor can bring in somebody else. If the Oil India says that we don't want like people like this, how can this court direct them to do that?
My lord, actually, what has happened is, my lord, they have approached the IOCL authorities.
Fine, whatever it is
Yes,
you don't have any contract between you and the IOCL.
Yes, my lord.
There is an intermediary in between.
Yes, my lord.
It is for him to make alternative arrangements for the contract
My lord, there is a section 226 of the Contract Act. My lord, if it may apply, my lord, if I may read, enforcement and consequences of agents' contracts. Contracts entered
Are
into,
you an agent?
my lord,
Are you an agent? You are an employee of the contractor.
of the contractor, my lord. My lord, the
That,
contract.
that is not envisaged in the contract.
Yes, my lord. My lord, the contract was entered into by the agent of the IOCL authorities, my lord. My lord, the contractors are the agents. So, my lord, their contracts with us will be enforceable.
Where is your contract with the agent of the? Where is the contract?
My lord, that is not on record. I can produce, my lord.
Yes, Mr. Kulta.
Lordship, page 52, they although wrote to the general manager, their prior to the under this circumstance, we requested to kindly instruct the contractor to issue the passes. So, it is
that's what I
ultimately.
said. There is nothing here between you and the IOC. It's something which is there between you and your employer, which is he is maybe an agent. And the IOCL is concerned with the vehicle. Let it be.
An appreciation letter they have annexed from page 33. It was issued by the CISF. Lord.
Yes.
Yes.
Okay, you prepare.
Yes, yes, my lord.
Your name?
G. Imtiaz, my lord.
D?
Imtiaz.
Imtiaz, Learned Counsel for the petitioner. 2 weeks time to further prepare the matter and make his submission. Accordingly, registry to list this matter again on 3/8/2026.
Deeply obliged.
File it.
Yes, Mr. Manaf.
My lord, 31 years of continuous service, my lord. My lord, he entered in service in 1995 and regular scale of pay was given in 1997. And his service regularized, my lord, only on, my lord, 2022. And my lord, now, my lord, continuous service in the same post, same capacity, 31 years he continued. And now, my lord, without pension.
Yes, Mr. Chakraborty.
Lordship is regularized on 22, Lordship.
22, but what
Lordship.
about the earlier period? That will
That
come
was,
in now.
that was not regularized, Lordship.
It is automatically regularized.
Lordship, kindly.
Sanjita does, if we apply here, he'll get it, he'll go beyond, beyond 2025.
20 years.
2005.
No, the sort, okay, accommodation is required, Lordship.
A. Manaf, heard Mr. A. Manaf, Learned Counsel for the petition. Also heard Mr. A. Chakraborty, Learned
Government advocate, Lordship.
Standing Counsel, Learned Government Advocate.
Appearing for
Also,
respondent number
Mr.
123.5.
Learned Standing Counsel, Finance Department, and Mr. S.K. Medi, Learned Standing Counsel, Accountant General. So, the petitioner hearing projects that she was initially engaged as Bal Sevika in the Social Welfare Department with effect from 15/3/1995 to top basis. The said engagement was being extended from time to time, and in course of such engagement, the petitioner was also authorized a scale of pay. So, the petitioner was regularized in her services with effect from 16/11/2022 and thereafter had retired from her services on reaching the age of superannuation with effect from 30/4/2026. The petitioner submits that she, having rendered services as on ad hoc basis with effect from 15/3/1995 and in recognition thereof, the services of the petitioner having been regularized on 16/11/2020. The period of service rendered by the petitioner with effect from 15/3/1995 is also to be reckoned as qualifying service for pension, and in such circumstances, the petitioner would be placed under the old pension scheme, under the provision of the, would come under the provisions of the Assam Services bracket Pension Rules 19. So, issue notice returnable 4 weeks. Mr. Chakraborty accepts notice on behalf of respondent number 1,
2,
3,
3, 4, and 5,
3, 4,
and
and
5.
5. Mr. H. Alia accepts notice on behalf of respondent number 2 and 7, while Mr. S.K. Medi accepts notice on behalf of respondent number 6. As all the respondents are represented, no formal notice. Baki Maridiba. Registry to list this matter again after.
Obliged.
Obliged, sir.
How is it maintainable, Lord?
Mr. Holy, relax, have your seat.
I'll sit down. I'm grateful.
Yes, Mr. Dury, what is your case?
Your Lordship, I'm challenging the so-called notice dated 12/5/2026.
On what grounds?
To your Lordship, may kindly produce page 382, Your Lordship.
332.
Your Lordship, then 384, that's the so-called notice.
84.
84, Your Lordship. Charge 1, if Your Lordship, at 383, the charge 1 starts. May I read from charge 1, Your Lordship, 383. The Gitartha Buru was posted as employment officer, district employment exchange, Nalbari. He appeared in the combined competitive examination 2013, conducted by the Assam Public.
So what is the ground for challenge?
Your Lordship, may kindly see 384. The consequence following therefrom is follows. Page 384, Your Lordship. The consequence, the third paragraph, the consequence flowing therefrom is as follows. So the allegations are against Rakesh Paul, not against me. There is no iota of allegation against me in the.
Okay, find your reply that there is nothing here that they should drop it. One ground. That was the ground. Then next.
And Your Lordship, one more thing, that embargo, Your Lordship, at page, Your Lordship, the judgment at page 379, Your Lordship.
You have not taken this plea in your reply also.
No, Your Lordship.
So next. So that cannot be. Then next.
The 379, Your Lordship.
379. Yes.
12, the petitioners, paragraph 12, Your Lordship. The petitioners having given up the previous.
That's the case. Now, in the earlier round of litigation, the court upheld the proceedings by removing the references to the one-man commission report.
Yes, Your Lordship.
That the authorities can proceed with the matter. Again, it gave a liberty to the respondents that no, if you want, go ahead with withdraw this, go ahead with a fresh.
Yes, sir.
Now, therein, you are a party to that proceeding also.
Yes, sir.
You have given a undertaking that if there are proceedings, we will not assail that on the ground of parallel proceeding. Now, when that order is there, if there is nothing against you, go before the authorities, bombard them with those materials. If they don't do it, face the proceeding, come back, we will see.
Your Lordship, kindly see page 377 for a moment, Your Lordship.
77.
377. The last, the penultimate line, Your Lordship. It is observed that in the circumstances fresh disciplinary proceedings are initiated, the disciplinary authority state cannot refer and rely upon the observation, finding and recommendations made by the commission against the petitioner in the report dated 2013 and 14.
Show me if there is any reference made to the findings of the commission here.
No, it is not there.
Yeah.
It is not.
So, Mr. Dury, inviting our opinion here, withdraw this. I'll give you liberty to file an additional show cause reply if required. Take all these points before.
One more thing, Your Lordship, the witnesses that in the charge sheet, the criminal trial, which is pending, Your Lordship, the same witnesses.
I cannot go when there is para 12.
But Your Lordship, 376 for a moment, if Your Lordship may kindly. 376, page number 376. Para 6. In the Your Lordship. In the circumstances, the disciplinary authority respondent state wishes to include additional documents and to provide list of witnesses. The petitioners having already submitted their statement of defense have to be provided with an opportunity to file additional statement of defense.
It does not get attracted in your case now.
But Your Lordship, the last line, the petitioners would be at liberty to raise such further or other defense permissible under law in their additional statement of defense.
Mr. Counsel, if there is a additional list of witnesses, additional list of documents is given, copies have to be furnished to you. Thereafter, naturally, you are entitled to make a further additional written statement covering all those things. That situation has not come. The only situation in your case is one, para 12. If para 12 was not there, you could have relied on Stanzen and all those line of decisions saying that parallel proceedings withheld, we could have kept it in a hold for a year.
Yes.
That's the maximum time given. We could have kept it for. But now that in the earlier proceeding, you having surrendered that right, if I may use that word, may not be appropriate. How can you come back in a fresh proceeding and say that this is to be?
In my respectful submission, Your Lordship, because these are fresh proceeding initiated, Your Lordship.
The fresh proceeding
Gives us fresh rights, Your Lordship. In my
No,
respectful-
this is placed after the liberty granted to the respondents to initiate a fresh proceeding. That is there at para 9 at page 378.
Yes, Your Lordship.
Time frame.
Thank you.
This is a general thing which will cover both. Or you go before that court, file a review, get this thing clarified. We have nothing to say. But I am bound by this. And I don't have the Sherlock Holmes power to go beyond that and duck.
My only respectful submission is because these
Your
are
first ground that this is with regard to the allegations are not against you, but with regard to Paul.
With Chairman, yes, sir.
You have not even vaguely also referred to that in your show cause reply. I'll give you an opportunity if you want to take that plea before the authorities because they have not appointed an inquiry officer till now.
They have.
And that is also gone.
Next date is 23rd, man.
That is also gone. That is also gone. Now you will have to take that plea in the inquiry before the inquiry. We will not.
At least I may be allowed to file a additional statement of defense.
You can, I'll permit you to take it in this plea in the inquiry in your statement. That much. Otherwise also you are entitled. If you want that much liberty, I can give you. Face saving. Otherwise, Mr. Dury, I would have understood a situation like there was a matter yesterday wherein they were not parties to the earlier round of litigation. Then maybe something we could have worked out. Here, you are a petitioner. That is the only doubt I had when I got the brief yesterday. Because there were a list of, I could not find out. Then I saw a statement of yours in the pleadings that you had filed a case.
Yes, Your Lordship.
So, Mr. Dury, no point. Take a call. Withdraw it. Comfortably proceed with the inquiry. Take all this, please, with regard to the sustainability of the charges against you for the inquiry officer.
Just one sentence. Lordship has been very fair and very this. I just have one thing from the state's perspective. Why I would hope that Lordship would consider an order, because there is additionally the point of Kuni Setti Satyanarayan in terms of once a show cause notice is there, writ won't come. More importantly, Lordship, there is always multiplicity of litigation happening on APSC. His withdrawal may lead to another petition coming up again.
That we will not give him a liberty.
So, no, not him only, others. So therefore, once it is dismissed on terms of merit, then he has his remedy in appeal if he wants, but another petition by a coordinate bench may not get considered.
I don't want any other proceedings on this to be sustaining here.
That's why I'm saying Lordship may actually move for an order.
Let him take a call. Yes, Mr. Invite us to dismiss, we'll dismiss.
Then I will withdraw, Your Lordship.
But Mr. T.S. Dury, learned counsel for the petitioner. Mr. Dury, after also heard Mr. N. Kohli, learned. Just write down your name.
Yes, we'll do that.
Mr. N. Kohli, learned senior counsel, assisted by so and so, Binath plus. So and so, and also Mr. S.P. Das, learned counsel representing the respondent number 3. Mr. Kohli, respondent number 1 and 2. Right? 1 and 2. Huh? No. 2 and 3, Mr. SP Das. Secretary? Okay.
We're all on the
Mr.
same side.
Kohli. 1 and 2. You appear along with Mr. Kohli.
He can appear in all matters.
And also Mr. SP Das. Also. Mr. Deuri, after attempting to argue the matter at some length, comma, in view of the queries raised by this court, comma, has submitted that he be permitted to withdraw the present petition with the liberty to raise the issue of the allegations leveled against him in the show cause notice to be not sustainable before the inquiry officer while adducing his statement therein. Also, the said prayer is not objected to by Mr. N. Kohli, learned senior counsel, appearing for the respondents. Also, in view of the above submissions of the learned counsel for the petition, the present petition stands dismissed with liberty to the petitioner to raise issues with regard to the with regard to his stand that to raise contentions before the inquiry officer appointed to inquire into the charges framed against him in the departmental proceeding so instituted, comma, that the charges so framed are not attractive to him. Otherwise also you are entitled.
I'm so grateful, Lord. I'm very grateful, Your Lordship.
Thank you.
So, Soma, you are a civil lawyer. What is that provision which permits the appellate court to take evidence in the CPC? Order 41. Order 41. In departmental proceedings also that is applicable. So what is your appellate authority doing? He raises a claim that 2-3 witnesses were not examined. Now the appellate authority brings them and examines them in the inquiry. Have you noticed that, Mr. Sharma? Page 88. Second paragraph.
Lordships.
The statement of the defaulting witnesses in presence of the recorded the statement of the defaulting witnesses in presence of the appellant as below. Page 88.
Yes.
Okay. Heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. S. Datta, learned standing counsel, revenue and disaster management, and Mr. Professor, along with Mr. A. Chakraborty, learned government advocate, and Mr. A. Cholia, learned standing counsel and Stefan. The petitioner in the present petition has presented a challenge to an order dated 9/6/2026. Where is the challenge to the impugned order passed by the
District Commissioner.
District Commissioner?
That is not an annex, Lordship.
It is annexed, Lordship.
It is annexed, no challenge.
No, sorry, not challenge, yes. I play for challenge for another.
If I set aside the appellate order, this order will remain. Have you made a challenge to that order? 27/6. 24.
That has not been annexed, most probably.
It has been annexed. Page 78.
70. Yes.
I'm allowing this appeal now only. This order I'm interfering, but I can't interfere 27.6. You'll still remain under
Dismiss.
being dismissed. You amend your writ petition prayer portion.
Lordship.
Or you want to withdraw, file afresh. Mr. R. Sharma, learned counsel for the petitioner. Sir, R. Sharma, after attempting to, after has submitted at the outset that inadvertently the order dated 27/6/2024 passed by the disciplinary authority imposing upon the petitioner the penalty of dismissal from service was not challenged in the present writ petition. In the present writ petition, the challenge is only to the order dated 9/6/2026 issued by the appellate authority. So, in view of the said error occasioning in the present writ petition, the Sharma submits that he be permitted to withdraw the present writ petition with liberty to refile the same, rectifying the errors noticed. So, prayer accepted. The present writ petition stands dismissed on withdrawal with liberty to the refile the same.
Okay.
May I please your lordship?
Yes. Why the person is subjected to such repeated transfers?
May obtain instructions.
You were sent from Udali to Azarbari.
Yes, my lordship.
Then while you were at, you had not joined, then the order was again modified.
Again modified.
And it was from Udali now to Bamuni.
Bamunigaon.
Now,
That is within
in Bamuni the person who was there, he
Yes.
was brought to Udali,
my lordship.
right?
Yes.
Person A, petitioner. Then the person who was there at Azerbaijan
My lordship.
was sent to Bamuni.
My lordship.
Now, both of them are not before this court. If I stay it, it will affect both of them.
My lordship.
You get my point?
Yes, my lordship. I'm getting
So today, you have to go to Bamuni
my lordship.
because in Udali, somebody else has joined. And in Azarbari, which you were sent, you had no grievance. Therein, the person has been retained.
My lordship, can this matter be taken after some time? I will get instruction whether anyone has joined to the new place of posting.
So even if not joined,
My lordship.
that person is there.
Yes, my lordship.
Udali.
My lordship.
That is Sofiul something.
Yes, my lordship. Yes, my lordship.
Come to page 17. Sofiul Islam,
Yes, my lordship.
Udali, transferred to Udali from Bamungao.
My lordship.
You from Udali to Azarbari.
My lordship.
And Pranab Kumar Mek from Bamungao,
Pranab
from Udali, Azarbari to Bamungao.
Yes, Pranav Kumar, my lordship, may page 18. His state, my lordship.
State. So
Yes.
you can't come to Azarbari.
My lordship.
Now, if we stay this,
Yes,
you will be in Udali.
my lordship.
But there is already a person at Udali who has been transferred.
My lordship.
Otherwise, I was.
My lordship, can I take your lordship for a second to Annexa 5, page 18, my lordship? My lordship, I have been now transferred to Bamungao.
In place of Sofiul Islam.
Sofiul Islam. And then the transfer order of this Pranab Kumar Mek is already state, my lordship, by
So
the
Pranab
department.
Kumar Mek remains at
Is
Azarbari.
Azarbari,
Sofiul Islam moves to Udali.
my lordship.
You were at Udali. Now you can't go back to Udali. You can't go to Azarbari.
my lordship.
So
neither
either
can-
one we don't disturb,
Yes.
we can't protect you.
My lordship, I understand. My lordship, can this matter be after summoned so that I can get that instruction?
Otherwise, I'm ready to stay this, but
Yes.
for this technical issue. Without hearing them,
Yes.
even if they are parties, we can issue notices,
Yes.
but they are not even parties.
My lordship, I understand. My lordship, after some time. Must
Please, Lordship, kindly adjourn the matter today, Lordship. J.K. Goswami is not well today, Lordship.
Lordship, on the last occasion, Lordship has
Lordship.
given a direction, Lordship, no further adjournments will be given, Lordship.
Matter number take number 2, my lord. PJ Monto is on legs at
J.K. Goswami,
Sir Das, that is adjournment refused when everybody is hale and hearty. If somebody has fallen sick, he is not keeping
not
well.
well.
Oh,
J.K. Goswami.
I didn't heard that, Lordship.
My heart is not that.
Lordship.
A prayer is made on behalf of Mr. J.K. Goswami for an adjournment in the matter on the ground that he is indisposed. So, in view of the set submission made on behalf of Mr. J.K. Goswami, raised the matter stands adjourned. To list this matter again on 37/2026.
Obliged, Lordship.
Lordship, can it be on either 29 or Lordship 31 Lordship?
31, no problem.
Obliged, Lordship.
Obliged.
So far as this case is concerned, the ASTC did not pay the PF contributions to the PF office, my lord.
My lord wanted me to obtain instruction how much they have paid. My lord, as against the assessment for the period from April 2015 to October 2016.
20 crore, 54 lakhs, 14.
That's right. My lord, they made payment of 12 crores for 84,000. 20.
After this many years.
Yes, my lord. Only seven or eight more, about 8 crores are left. My lord. They have not paid.
My lord,
That period.
My instruction is, my lord, this instruction is on 15 July 26. That is on in the file, my lord. We are in last occasion, PF amounts paid for the last 3 months were as follows, my lord. These were paid, my lord.
We are not concerned with that. We are concerned with.
Kindly appreciate, my lord.
We are concerned with 6928 areas.
That have been paid, my lord, according to my instruction.
Everything paid. That means-
Only 3 months. 3 months is left out of 2023, not 15-16.
No. I want instruction with regard to 69/2018.
69?
2018, page 33.
That is what my instruction is.
No, this is not that.
Page 33. This amount is paid, my lord, according to my instructions, my lord. Kindly see,
Give
my
him a
lord.
copy.
I'll give him.
Mr. Suma, have this copy. We will take it up after some time. You get your instructions.
My lord.
Can
Can it be at 2 o'clock, my lord?
2:15,
My
whenever
lord.
it's possible.
Well, I'm just told by the Advocate General that he has been free from the other matter. If your
3:30, we
lordship,
have fixed it, so we'll have it at 3:30.
my lord. 3:30 to come matter, sir.
You get your instructions
Right now.
from we have got the instructions from Mr. Roy. He's not required.
My lord.
So his junior can be around. You get your instructions.
My lord. I'm just sending it right now.
There is no representation on behalf of the petitioner. Matter is called. So, Devi Bora, Lanan. Bora. Standing Council, Health and Family Welfare Department is present. Registry for the ends of justice this matter again. After in the first week of August 6.
Where is the last order dated
This is your lordship. Lordship kindly pass over the matter for time being, your lordship.
Release of the leave encashment, that's only instruction.
Yes, yes, yes. Yes, what is your instruction?
Lordship, we have received the instruction, lordship. As my senior is engaged in another court, lordship, I am unable to get the instruction. Your lord.
Time being. Okay.
May I please, your lordship? My lord, in this case, my lord, we are preparing this, my lord, affidavit. My lord, because of the some health issues, my lord, the petitioner could not come. Considering this aspect, my lord, lordship may kindly 2 weeks time may be granted, my lord. In the meantime, we'll file.
Mr. DK Das, learned for the petitioners. The affidavit on behalf of petitioner not be filed on account of the fact that the petition was indisposed. He submits that such affidavit would be filed on or before. On or before?
My lord, prior, my lord, 2 weeks, I will file, my lord.
2 weeks. Okay. On or before 5/8/20. Registry to list this matter again 13/8/20. Also, a matter be not treated and or tied up matter with this court any further.
Obliged.
Obliged.
Yes.
My lord, may I make a prayer, my lord? My lord, my instruction is that, my lord, my senior will be addressing your lordship, my lord, in this issue, my lord. So, my lord, may I pray that the matter may be adjourned for today, my lord?
We had kept this matter
Yes, my lord.
in terms of your prayer only. Your grievance is page 72, 73.
Is on VC.
Huh?
F1 is on VC, lordship.
Oh, yes, Mr. Khan. Your
My lord,
grievance is
yes, lordship is taking up WPC 1432.
no, what is your grievance? Your grievance is the suppressed seniority given to you and the seniority given to the private respondent. Above you.
Yes, my lord. Yes. He got a
Mr.
fresh
Decca,
appointment.
Mr. Decca wants an adjournment that his senior is not here, so his senior wants to address this court on the matter. We'll give him an accommodation.
My lord.
I'm deeply obliged.
When do you want it?
Well, can it be on 3rd or 4th of August, my lord, if it's not inconvenient? Fourth,
On
my
the
lord.
prayer of Mr. R.M. Decca, Learned Counsel submits that the matter be that an accommodation be granted to him in the matter today, inasmuch as his senior K.N. Chaudhary is not present. Also,
Lord, he is here, my lord, today, but my lord.
okay. Mr. R.M. Decca submits that he be granted time till 3/8/20, 4/8/2026 to make submissions in the matter.
My lord.
Prayer is not objected to by Mr. F. Khan, Learned Counsel for the petitioner. For the petitioner, the above noted too. So, in view of the above, registry to, in view of the submissions of Mr. Decca, registry to list this matter again on 4/8/2026. The matter be not deemed to be parted and or tied up matter with the
Biplab.
Obliged,
I beg to make an out of turn submission, my lord. Item number 4, my lord, senior counsel Mr. P.K. Tiwari is in this matter is outside, my lord, it escaped my attention. I pray.
have already come across. Nobody was here.
My lord, it escaped my attention, my lord. I'm deeply sorry, my lord. May the matter be taken up, my lord? I'll inform him.
Now we are proceeding with admissions. Now we can't go back. We'll complete the admissions and then see. Yes, any development? Where is Mr. Das?
my lord, the government has
Yes, Subramaniam, what is the development?
They have again submitted the proposal, but without the
NOC.
NOC, Lordship, and that, Lordship, we have scrutinized, and that cannot be, Lordship, permitted.
What is the amount recoverable from him? Have you determined?
No, nothing has been done.
Oh, Mr. Please have your seat. Yes.
There is a report, my lord, we have said. The
When did
report,
you retire, Mr. Purkhaisto?
I returned on my lord 24, my lord. 30/11/24.
24. Only leave encashment is left. What is the amount?
Will be a average of 10th month
Salary.
salary.
Oh, you're a professor, assistant professor. What
Yes.
were you?
The principal, my lord.
Principal of the college.
Yes.
That means associate professor. Yes.
My lord, if it is, say, if lordship finds that the non-liability is not required, then my lord, I have
That is different thing. What is the liability, you tell me?
liability, my lord,
Now it is around 2 years that he has retired.
that's right, my lord.
Then what is the liability?
But we have forwarded a audit report, I mean, the inquiry report to the government. That lordship will find at
Oh,
page
no,
1.
inquiry report means what is the amount recoverable from the petition?
My lord, he has given it, my lord.
What is that? Just tell me that.
My lord will find at page 110
Yeah.
of the affidavit that 110, that affidavit, affidavit we have filed, my lord, additional affidavit. There are various.
So total is?
One is,
These
my lord,
are amounts. No, where is the finding that these are to be recovered from the petition?
yes, my lord, this amount are withdrawal by the Saraswati Puja account, lordship page 111, that this is not deposited. No bills, no vouchers found maintained. So, my lord, these are all done by him, my lord.
Yes, what do you have to say on this, Mr.?
This account, there is no audit report against this account as on today, my lord. These are they have only stated, my lord. Where is that? But that I have, my lord, audit report has stated that I am liable, my lord.
Yes. Where is the audit report towards the Saraswati Puja account?
No, that, my lord, that for audit, we are not going to, this is the government. That the government has.
Where have you got this?
This is the
Has
inquiry
not
made.
been audited ever and no cash so and so, so and so.
This is by a committee, my lord. We have constituted.
Okay, Mr. Das, Mr. Upamanyu, he will give a indemnity bond. Release that amount to him. Thereafter, if something is to be done, he will give an undertaking also that will be permissible to be recovered from his pension.
As per procedure.
Yes. So, the heard Mr. B. Purkhaisto, learned counsel for the petition. So heard Mr. I also heard Mr. D. Upamanyu, learned planning counsel, higher education, and Mr. P.K. Roy, learned senior counsel, assisted by Mr. B. Das, learned counsel, appearing for the
S1 of 4 to 10.
Respondents number 4 to 10. So, the petitioner in the present writ petition, while serving as the principal of
Rabindra Southern Girls College, my lord.
Rabindra
Southern Girls College. This is synopsis. My lord, may I take leave? My lord?
Serving as the principal, Rabindra Southern Girls College, Karimganj, had retired from his services on reaching the age of superannuation with effect from 30/11/2020. So, from the materials brought on record, it is revealed that the pension of the petitioner was duly authorized and the same is being received by the petitioner. With regard to the pensionary benefits, other pensionary benefits are receivable by the petitioner, barring the amount under the leave and under leave encashment, comma, the other pensionary benefits have also been released to the petitioner. The respondents have projected in the matter that in view of the fact that the college authorities had not issued an NOC in the matter, comma, the leave encashment benefits of the petitioner could not be processed and released to him. So such a statement is so made in spite of the fact that without an NOC, comma, the pension and pensionary benefits of the petitioner was already the pension and other pensionary benefits were already released to the petitioner. Mr. P.K. Roy, learned counsel for the senior counsel appearing for the college authorities by referring to an affidavit filed on 1/12/2025 by the college authorities has submitted that in pursuance to an inquiry conducted by a committee constituted by the governing body of the college, comma, an amount of rupees 5,34,808 is found to be recoverable from the petitioner. On a query made as to whether any proceedings have been instituted with regard to the in connection with the said unauthorized retention, unauthorized with regard to any misconduct on the part of the petitioner in connection with the utilization of college funds, comma, it was fairly submitted that no such proceedings have been instituted till this date. Also, in view of the above position coming on record and the petitioner having been found to have already retired from his services on 30/11/2020 and there being no material to and no proceeding having been instituted against the petitioner for drawal of a department in connection with any misconduct committed by him, this court directs the petitioner to submit an indemnity bond to the Director of Higher Education, Assam. So, the petitioner shall also undertake before the director that in the event any amount is found to have been so quantified to be recovered from him in pursuance to a procedure known to law, comma, he shall refund the said amount without any further objection. So, in the event the said indemnity bond is so filed by the petitioner along with the undertaking as noticed here in above, undertaking shall that the amount shall be recoverable from his pension in accordance. Also, in the event of filing of any such of the above indemnity bond as well as the undertaking, comma, the Director of Higher Education shall proceed to release to the petitioner to compute and release to the petition his due amount against a leave encashment benefits. Also, with the above observations and directions, the petition stands disposed of. Mr. Roy.
My lord, the amount is, my lord,
5 lakhs something.
No, my lord, it's 9, 10, 37. The next page, there is another. The total would be 9,10,000. I mean,
whatever it is. You have not instituted any proceedings against.
That's right.
You institute proceedings, quantify that amount. He will give an undertaking that this, he will return it.
That is the most appropriate order, my lord.
Also. Or should I write as agreed to by all the parties?
No, my lord, let it not be.
Remind you.
Within a period of, my lord, in the event of
shall
submission.
be released to the petitioner within a period of. They don't have money.
2 months.
2 months.
Obliged.
Deeply blessed.
Now the next will be a contempt petition. You're not going to give.
They are not issuing the
Huh?
liability certificate. They are not issuing the NOC.
Oh, now
No,
he
no,
issue
no,
a
it's order.
indemnity and undertaking.
Yes.
Give him. The college does not quantify what is your headache. If they quantify in a manner known to law, he will recover it from his pension. That's all.
My lordship has asked me to take instructions. I can receive that.
We'll call it back.
Okay, sir.
Well, the petitioner was initially appointed as a stipendary teacher, and thereafter, on completion of that basic training, he was given regular scale.
You have not challenged this 31/2021.
That is because, my lord, I retired about the same time I filed this, on 30th of April.
Be that as it may.
So my prayer, my
No,
lord.
your this thing, you have accepted this from 21. You worked till 26 without any objection. You retired, then you have now come up.
Even then, my lord, this undertaking is artificial. Supreme Court is clear.
No, Supreme
clear.
Court, maybe by that time the can reach there.
I may.
But as far as I am concerned, I have dismissed this.
No, my lord, only one thing, madam. They have already given me part of the relief that I paid for, madam. The 3 months area salary was not paid under the 21 order. That has been cleared, madam, very recently. So my only, my lord, prayer at this stage, my lord, will be, my lord, that from 2012 to 2021.
The problem here, Mr. Goswami, is that you, by subjecting yourself to that screening process, had also taken in, has also accepted that you were illegal and or irregular.
My lord, I'm a beggar, my lord. I didn't have the opportunity to, my lord, choose, my lord. I was not given any option, my lord. I was not paid from 2012 March.
Where is your affidavit?
Lordship, affidavit is not filed yet, Lordship.
Not filed. Will not file.
Will file, Lordship.
You'll file.
Lordship.
But Mr. B.D. Goswami, Learned Counsel, P. N. Sharma, Learned Standing Counsel, Second Elementary Education Department. Elementary.
Elementary, Lordship.
So Mr. Sharma submits that an affidavit on behalf of the respondents represented by him would be invariably filed on or before 14/8/2026. Registry to list this matter again on 27/8/2026. The petitioner is at liberty to file a rejoinder to such affidavits that would now be filed by the respondents. Also, registry accordingly, registry to list this matter again on
27th.
7/8/2026. So matter be not treated as parted and or tied up matter with this. You try.
My lord, I tried to impress when he said I am retiring and all that.
Everyone has a hope now.
That's all.
May I please, your lordship? Your lordship, Mr. KP Pathak is conducting this matter. He has some medical emergency. Kindly maybe fixed on the next week.
When was the penalty imposed upon you?
Penalty was imposed on lordship
2014.
Lordship.
Appeal?
Appeal filed lordship on 18/8/2014.
What were you doing from 2014? 10 years.
Then there was some delay lordship. We are
Not some delay. That delay is fatal to you. You have not explained that.
I also made some RTI application lordship, but they did not
You have
provide.
not made any explanation.
Delay lordship, some explanation. Delay.
So this delay, account of this delay, we can dismiss you. Anyway, today, Mr. Pathak, there is a problem. He is not there. So we will have it some other day. Heard Mr. S.K. Das Lanaka for the petition. So heard Mr. Also heard Mr.
C. Paul.
C.
Paul.
Learned Counsel appearing for the respondent. Mr. Paul submits that the arguing counsel, Mr. K. Pathak, is not present in the court today on account of certain. So, accordingly, he prays that the matter be taken up after 2 weeks. Registry to list this matter again on 11/8 on 6/8/2026 for admissions.
All right.
Much obliged.
Yes, what is the service record say?
My lord, with your lordship's permission, may I produce some relevant document which have got access to lordship?
What does his service document say, Mr. Chutia? What does the service say, record say? Who is the nominee?
Lordship, this, we have got recently got hold of this document, lordship. May kindly come to the last page of that document, lordship. That is the submissional oath made by the private respondent limited in the MSCT court, lordship. How this document is relevant, lordship, may kindly look at the very first line, lordship. Respondent number 10 herself has admitted she is the second wife. This is a submission made before a judicial forum, lordship. That itself nullifies their contention in their affidavit, lordship. We'll of course bring this on record, lordship. Apart from that, the first page is the voter list, lordship. Dear lordship, may kindly turn to page number 2 of that set of document. Lordship, may kindly move to serial number 626, lordship. All the 3 persons are together, lordship. Against my name is also Swami Tazimbar Hussain. Her name is also Swami Tazimbar Hussain. In order, against both of our names is Swami is written as Tazimbar Hussain. We admit that she is the second wife, but she is not admitting. In order to bypass Rule 143(2) and Junifa BB, she has malifiedly claimed that I am not at all the wife. Lordship.
Yes,
Well, please, your lordship. Lordship, what if
your statement before the MSCT court.
I do not have that, my lord? Let them bring on record, my lord. Let them file affidavit so that, my lord, I could file.
If this comes on record, then what will you do with your statements in your affidavit? You have made wrong projection, that means, for this court on affidavit. Where is that affidavit? Yeah, Begum.
Page 73, my lord.
So here you deny that the petitioner is the legally married wife of Tajibur Singh, right?
In para 4, my lord, page 74, I have submitted that their marriage is doubtful, my lord. Why doubtful, my lord? Because whatever address she has
No,
given.
but you have in your that place said that wife of the first wife.
Lordship, I have not this today, I have received, my lord. It's up to your lordship, my lord. Because on oath, my lord, she have submitted before the MSC, my lord, MSC court.
My lord, address, there is no legal bar on a person.
Okay,
There is
Mr. M. Ahmed.
NZ Chaudhary.
NZ Chaudhary, learned counsel for the petitioner, submits that the petitioner has received certain documents, has in her possession certain documents which would be useful for the adjudication of the issue arising in the present petition. Mr. Chaudhary submits that the perusal of the said document would go to reveal that the respondent number 10 had, during her deposition before the MACT, before the Motor Accident Claims Tribunal, Porpeta, in connection with the claim raised, they made therein for compensation for the accident occasioning to the husband of the petitioner and the respondent number 10. The respondent number 10 on oath had stated that she was the second wife of the deceased government servant and the petitioner herein was his first wife. Also, to afford an opportunity to the respondent number 10 to rebut such contention raised by the learned counsel for the petitioner, the petitioner is directed to bring the said documents on record by way of filing an edition. Also, the Learned counsel for the respondent is also granted liberty to file a rejoined objection, an opposition, a rejoined objection thereto. Or thereto. Accordingly, the learned counsel for the petitioner shall file the additional affidavit on or before 3/8/2026. The learned counsel for the respondent number 10 shall file a rejoinder thereto on or before 14/8/2026. Court objection 14/8/2023. Registrate to list this matter again on 24/8/2026. Right, take this back.
In this case, I filed my affidavit on 20th lawsuit.
May I please, your lordship. Lordship, the grievances of the petitioners herein is very limited. We are challenging one provisional gradation list, lordship, seniority.
When was the order passed in your case?
Earlier case, lordship.
No. Regularizing you, that exact order was passed on which date?
Lordship, by way of an order from this honorable court.
I know that order will have to be
2017,
transmitted by an
lordship.
executive order.
Yes, lordship, that order was passed in the year 2017, lordship. 17/1/2017, I have annexed it as Annexure D, lordship.
Annexure D.
Annexure D. From page 26, effectively at page 28.
No, that is the order of this court.
Lordship.
Requiring your consideration of your case for promotion or upgradation.
Lordship.
Where is the consequential order passed in after this?
Lordship, I have not annexed that.
Okay. When were you appointed on?
2019, lordship. 2019.
19?
19.
2019.
19.
Now, where is your name in the seniority list?
Lordship. Out of that, 26 numbers of the left out persons, lordship, 9 has approached this honorable court. Lordship, the petitioners herein are, lordship will find at page number 31. Sorry, page number 73 onwards, the at page 73, lordship.
Yes,
that
559 is Panesha Saloi, the petitioner.
Panesha Saloi, lordship. At page number 73, 551 Dilip Hatimota, 552 Deepak Saikia, 553 Khorgeshwar Nath, 554 Lily Chutia Deka, 556 and 557 Hemkanto Nath, Jiten Dotto, 559 petitioners, Praneshwar Saloi. These are the persons, lordship.
And where is the earlier batch of that persons who were regularized?
Here, lordship. They are not here, lordship. In this
Earlier
provisional.
batch? The earlier batch, who were regularized and you were left out?
They were regularized in the year 2009, 2000, lordship.
2000. Okay, let us see the direction of this code.
Page 26, lordship.
Okay, this direction was passed on
17/1/2017.
Now, have you assailed the orders, delay in the delayed orders passed promoting you or upgrading you as to that grade 3 post?
Lordship, we had approached the department, but
that order is of 2019.
Lordship.
So your regular appointment in service occasioned on 2019.
Yes, Lordship.
That being not under challenge here, I cannot touch that. I cannot give it a retrospective effect.
Lordship.
So what is the error? If you had made a challenge to that order, saying that for X, Y, Z, whatever, then we could have considered that. And if we give you a retrospective thing, you will get it.
I leave it up to your lordship now.
Why you leave it to me? You make your submissions.
Lordship, this is a fact. We have not assailed that.
So find out a way. Why surrender immediately?
Lordship.
I'm only pointing it out to you. You're a young counsel. If there was a veteran appearing, I would have dismissed it. Giving you an opportunity. Find out a way. It's not.
Lordship, I am
still in the ventilator. You can bring it out.
Lordship.
Challenge that.
Lordship.
Amend it. Come back. We'll see. And you, orders are passed by this court in 17, you wait till 1 month time, you wait till 2019.
Lordship.
Huh? When?
Lordship, after 2 weeks.
Your name?
Dr. P.P. Mehdi, Lordship.
Doctor?
P.P. Mehdi.
P.P. Mehdi, Learned Counsel for the petition. Submits that he be granted 2 weeks time to file an application for amendment of the writ petition. So pre-accepted. Registry to list this matter again on (10/8/22).
I'm obliged. Petition filed by the Chief Judge, Lordship, that may be take, Lord.
That will come.
Lordship, Lord.
What have you stated? Give me affidavit copy.
Lordship already, Lordship take note of that, Lordship.
The affidavit
He was
is not
promoted
yet-
only on 2019, so his seniority will count after 2019, Lord.
That much only.
Lordship, Lordship.
I'm obliged, Lordship.
These are all subject to limitations. You will have to cover every aspect of the
Lordship.
matter.
Obliged.
Yes, done with.
My lord, they have not given the charge of the HOD.
Why?
My senior is selected on court number 22.
Okay, after some time.
Yes, ma'am.
No orders passed. Other things they have given you. They have passed any order that
They have-
committee participation, this, that. Nothing, no orders.
Possibly, I think they have not communicated.
Okay, let Mr. Manang.
Wait, please, your lordship. This connected IA is filed for implement of
But Mr.
S.A. Wasi.
S.A. Wasim.
Wasi. W-A-S-I.
Wasi, W-A-S-I. You're not here in the case.
I'm on behalf of Mr. Emeshik.
Appearing on behalf of Mr. M. A. Sheikh, Learned Counsel for the petitioner. Also heard Mr.
S. Sharma.
S. Sharma, Learned Counsel, appearing for the
Forest Department respondents.
appearing for all the respondents, for all the opposite parties. The present interlocutory application has been instituted by the petitioner. Praying for permitting him to implead the
Karbi Anglong Autonomous Council.
Karbi Anglong Autonomous Council as a respondent number 6 in the connected writ petition. Where is the address? Karbi Anglong. Karbi Anglong, what is the address? It's the Karbi Anglong Autonomous Council represented by where? What are you?
Represented by Principal Secretary.
Where have you written?
Para 5.
Represented by its principal secretary as respondent number 6 in the connected writ. So it is projected by the Learned Counsel for the applicant that the petitioner you are still serving under that. You are still serving in of having served under
During the period of
having served under the
2017 to 19.
Autonomous Council during the period for which a claim for areas release of authorization of area salaries is made in the connected writ petition, the Karbi Anglong Autonomous Council is a necessary and proper party in the connected writ petition. They said contentions raised by the Learned Counsel for the petitioner is not disputed by the Learned Counsel. So, in view of the above, the petitioner is permitted to implead the apostrophe Karbi Anglong Autonomous Council, represented by its principal secretary, Difu, District Karbi Anglong, Assam, apostrophe over, as respondent number 6 in the connected writ petition. With the above observations and directions, the present interlocutory are disposed of. Main writ petition.
Much obliged.
In view of the order passed today in I bracketed C number 2167/2020, permitting the petitioner to implead A to A, so and so semicolon as respondent number 6, as respondent number 6 in the present petition, comma, petitioner to file an amended cost title within 2 working days. Also, issue notice to the newly implemented respondent numbers. Ms. P. Shori Learned, Standing Council, Karbi Anglong Autonomous Council accepts notice on behalf of the 6. No formal notice. However, requisite extra copies of the be furnished to the presenting bill. Registry to list the matter after 4 weeks on a day.
Elijah Lodge.
May I please, Your Lordship?
Rationalization done.
No, my lord, that was not more completed. My lord, last occasion, CDPO Lala was directed to be file an affidavit.
He's not filing.
No, I have received the instruction, my lord. I will file it.
No, what has happened as the rationalization?
He says something, my lord, director says something. That's why I will have to.
Okay, we'll ask the director to come online. We'll talk to both of them on, let them come online. We will have a discussion.
Let me first file this affidavit, my lord, because I have received it at a long time. I will file it.
Stand is very clear because the selection process was done as per approval lordship made
Of the director.
by the director. Now he cannot turn. Unnecessary.
Okay, there is an order of this court for requiring.
Yes, it is there.
Let him file. We'll ask him to file it on a very short date. Mr. T.C. Shutia, Learned Senior Counsel, assisted by Ms.
Jay Sharma.
Jay Sharma, Learned Government Advocate, submits that the instructions in the matter has been received and an affidavit on behalf of the respondent number 3.
Yes.
CDPO.
No, not 3. CDPO, I think 4.
CDPO lordship.
Respondent number 5.
5.
Would be filed without fail on or before 5/8/2026. Registry to list this matter again on 12/8/2026.
Deeply obliged, my lord.
None appears for the petition on call. For the ends of justice, registry.
My lord, are you like it? For some time, my lord, my senior coming, my lord.
Yes, what is the case?
The case is continued suspension, my lord, prolonged suspension, my lord.
Wait some time.
He's coming, my lord.
Who? But it will take some time. We'll finish the list only, then only.
Son. But in this case, my lord, mine and my learned, my lord, respond number, my lord.
Number 4. Yes.
4, my lord, is given the in-charge headmaster, whereas I am the senior most, my
There
lord.
is some affidavit filed by.
Yes, they file, my lord.
Huh?
Yes, the director filed an affidavit on 17/7/2020.
Have you given a copy to all?
Yes, my lord. My lord,
Mr.
I have also got.
Want to make any, want to go through it, or shall we take up the matter for?
My lord, not necessary, my lord. I have already.
Page 69, your lordship.
Okay.
The affidavit in opposition.
An affidavit in reply has been filed. Affidavit in reply has been filed by the petitioner against the affidavits filed by the respondent number 4 and respondent number 2 and respondent number 4. So the same is taken on record. So registry to list this matter again on 30/8/2026, 7/2026 for admission hearing. An endeavor would be made for further hearing. I have not gone through it. Let me also go through it.
37.
Understand.
This issue is pending before the division.
On 18/8, the appeal is fixed.
18/8. Registry as prayed for by the Learned Council for the parties, registry to list this matter again after. Registry to list this 25.
18/8, 18th of August.
On When have we fixed the matter yesterday? Similar matter,
Oh, that matter is different, Lordship.
different, okay.
That got dismissed,
24,
Lordship.
24/8/2020.
Yesterday, SLP, Lordship.
No, there was a similar matter.
Oh,
It is the fixes. Look. 24.
Lordship.
Lordship, notice was issued in 2021. Last order is 22/10/25.
And 3,000 cost was also imposed. Still no affidavit, no cost deposit. Where is get Mr. Ghosh or somebody from the Ghosh is there. Just get it, we'll see. Yes, why the amount is not paid?
This is directed by the SC fine, revenue lordship.
Okay, get hold of a revenue. Revenue Council.
Lordship. Will inform lordship. On
Everything is there. the money
13/7
should-
lordship, that
Huh?
was, on 13/7 lordship, it was
No,
directed by
the
the.
director, you have district commissioner has filed, who has filed this affidavit? Bachaji, district commissioner has filed. Why the
lordship.
amount is not released?
So it was kept pending in the revenue department lordship.
Proposal has gone.
Proposal has gone
Okay,
lordship.
get hold of that. We'll get it.
Published.
Mr. Tiwari, how long will you take in your matter?
Issue is very small. And I understand my lord is very familiar with these issues. Because your lordship also had an occasion to deal with it. Here is a case wherein the petitioners are the lecturers in the government homeopathic colleges.
Yes.
And they are seeking parity
Similar
the-
matters
with
are
the
pending,
lecturers.
Lordship. Similar matters are pending, Lordship.
We'll finish up.
Many cases of this nature were disposed of by this honorable court. There are orders. Total, my lord, there are 3 judicial orders on record in this very particular case. I understand in one matter possibly your lordship appeared. In 2 other cases, other counsels appeared.
This
And,
matters is fixed on 27th, Lordship, 27th of July. Ganesh Chandra Bora.
July,
27th of July, that matter was fixed, Lordship.
which cases? Would you please tell me the numbers?
But it's 6375 or 15.
6375, I don't know.
Dr. Ganesh Chandra Bora.
How do
Similar
I know?
matters are fixed.
Yes,
Ganesh
Lordship.
Chandra Bora.
On
Just a minute.
27th, Lordship,
185,
Monday.
180. Ganesh Chandra Bora, but it is also
But
disposed of.
there is a decision of
This was up.
my Lord Justice Manojit Bhuya,
There is another 208. Lordship, may kindly see 208.
page 20.
Yes.
That is the minutes or decision
208, I understand, is the
order.
order of Justice Surana. This is also Ganesh Chandra Bora.
Oh, that matter.
Yes.
Mr. Tiwari, I think I should not be.
Yes.
Should not, but the petitions are different over here.
Issue is same.
That is why I thought it fit to show this to your lordship first. In fact, when I turned the pages,
Lordship, you can-
Registered to this matter before any other bench without.
but my lord, it should not be, at least if, because next week I'll be here in Itan.
As an urgency has been expressed by the learned senior counsel for the petitioner. Registry to.
On 27th, Lordship.
27th
27th, and
When are you going to?
27th is this week, next week.
next week, Monday, Lordship.
I'll be here, no,
Monday.
27th,
Yes.
23 to, my lord, I may not be 23.
27 is Monday.
27th is Monday. Just a minute, roster is. My lord, lots of problems.
No, please have your.
Because next week I have to be. Yes. 34, no, yes, I'll be here.
On 27.
Yes,
7,
I'll be here.
2026.
I'm like,
Wait, please, your lordship. My lord, the High Court order is at page 112, my lord. And your lordship may kindly come.
How is the violation? What is the violation?
Violation is, my lord, 114, para 4, my lord. Mr. P. Hendrick, Learned Counsel, appearing on behalf of the State Court Learned Counsel of the PNRD, submit that the petitioner would be entitled to all the pensionary benefit as per the new pension rule after verification. And
So
thereafter,
what
my-
has not been done?
and thereafter, my lord, at page 7, my lord, para 7.
Huh.
Here, my lord, three parts, my lord, order are, my lord, directed to verify the service of the petitioner husband and thereafter pay all the pensionary and other benefits due to the petitioner. In
Where
terms
does
of-
it say old pension?
No, I am not asking for old pension, I am asking for the new pension.
Then why
They
it
are
is
not giving, my lord. And they are taking the plea that 1 year has not been completed before, my lord, petitioner was, my lord, died, my lord.
You will not be entitled to a compassionate family pension.
Yes, my lord.
You will be entitled.
No,
Then?
only new pension scheme, my lord.
Yes, madam. Why the new pension? Is he a subscriber?
Lordship, here I'm for respondent number 3. The PNRD department has to decide on that, Lordship.
Where is the PNRD department? Yes, Mr. Ghosh, what has happened?
Last day an instruction was placed.
Hmm.
That because of service, it's only 1 year of
I'm
qualification.
sorry, if he is a NPS, covered under NPS, you had
Sure.
made deductions from the date he was working. That much amount will have to be given. Where is this 1 year thing coming in now?
Okay.
Under NPS.
Chief,
Under NPS, how can you, whatever deduction is made, whatever accumulation has occasion, that has to go to him.
Lordship may grant me a week's time to get the
They have
update.
been granting you that only from the way word go.
Because the last instruction was that because of only 1 year service from the
How can that be? He is not claiming old pension scheme. He is not claiming your compassionate family pension.
Chief.
He is claiming NPS benefits. Now, if it is NPS benefits, whatever has been accumulated there, that will go to him.
Lordship may kindly grant me some time.
Mr. Ghosh submits that the instructions in the matter are not complete and prays that the matter be taken up again on 29/7/2026, by which date he shall apprise this court as to why the NPS benefits of the petitioner has not been released.
Obliged.
Obliged, Lordship.
Made to the lordship. My lord, in terms of the order which was passed on my last occasion, previously, before the last occasion, my lord, that is to be specific on, my lord,
Have you filed an application for
Yes, my lord.
AIDC?
Yes, my lord, we were about to file, but something, my lord, had come up from the respondent when they had filed this affidavit. My lord, the last affidavit in the record, if your lordship sees, wherein they have now made a statement that this organization, that is AGCC, doesn't even exist. Now, on the last occasion when submissions were made, there was a submission on their part saying that it has been taken over.
We close it.
No, my lord.
Then?
The last occasion when he made the submissions that it has been taken over by the AIDC, Assam Industrial Development Corporation, so it should be impleted as a party, my lord. We were on the verge
You
of...
don't want to implement that?
No, we will now pursue the matter because instructions have to be seen really whether their affidavit, whatever they...
What is AGCC got to do with AIDC? AIDC is a continuing
Exactly, my
organization.
lord.
AGCC may go.
Yes, my lord.
It is liquidated.
Yes, my lord.
But the money, if there is any claim, that has to be paid by some authority of the government. And AIDC is the nodal agency.
Yes, my lord. So that is where we want to file an affidavit in reply to their in response to the
On the
affidavit.
prayer of the, this is for orders.
Yes,
Why is it come up for orders?
my lord, because I wanted to file this impleading application, my lord.
Okay. On the prayer of Mr. Fusa, it is submitted, it is seen that no impleading application has been filed by the petitioner to implead. No interlocutory application has been filed by the petitioner to implead the Assam Industrial Development Corporation as a party respondent in the present. Mr. Bura Gauhati, learned counsel for the petitioner, submits that as it is now projected by the petitioners, by the respondents, that the AGCC Limited does not exist as on day
Paragraph 12, my lord.
on its being liquidated, pursuant to its liquidation, he submits that before filing of an interlocutory application, an a reply is to be filed against the said affidavit. Also, considering the issue arising in the present writ petition, while granting opportunity to the petitioners to file their rejoinder to the affidavit filed by the respondent number 3 and also to file interlocutory applications, the matter stands adjourned for 8 weeks.
I'm highly obliged, my lord.
I'm blessed.
Wait, please, your lordship. Lordship, we are being led by Senior Counsel Mr. K. Chaudhary. He's on legs. My lord may take it up.
For respondents.
Yes, madam.
We'll hear Mr. Bachchaji for some. Mr. Bachchaji, the interim direction was passed on a impression that there was no delegation of power to the
Lordship.
But with regard to page 18, you have now brought on record that there was a general order issued. Mr. Chaudhary.
Yes, sir.
No matter. No objections have been filed.
Yes, yes.
Objections filed.
No, we're fine.
Not on record. You have received?
Yeah, Lord, if your lordship should kindly permit me, my lord.
Lordship, as you are aware, this relates to an issue of a show cause notice. Lordship.
No, the thing is, page 18.
On page 18, the instructions are there. The Lordship, it was stated that it was without the governing body. In page 18, specifically it has been given that may I read, Lordship? Advice and counsel of the governing body sought for speedy redressal of various issues, primarily relating to complaints, non-performance, indiscipline, etc., arising in the institute. The governing body has taken serious note of the various issues relating to complaints, non-performance, indiscipline, etc., arising in the institute and advised the executive director, AIMS Gauhati, to constitute a fact-finding team immediately when such incident occurs, followed by an inquiry committee as the case may be. In the instant case, and this is specifically given, the governing body has advised the executive director to change the HOD, community and family medicine, with immediate effect. Further, the governing body further empowered the executive director to take appropriate action as per the terms and conditions of the offer of appointment, /CCS conduct rules, /CCS-CCA rules, /AIMS regulations against any kind of misconduct by faculty, officers, staff, including extension of probation period and termination of service if required in order to maintain proper discipline within the institution. So one point is very clear that he has been empowered, Lordship. The second issue is
what is the date of this decision?
The Lordship, the page 18. The governing body dated 09/09/2024. September 2024.
And when was the show cause notice issued?
Lordship, the show cause notice was issued on 27/05/2026.
So this decision, according to you, is a general.
It
was
specifically for this particular petitioner. It was specifically.
So how did the when was it taken to 09/09/24?
09/09/24.
And
there has been a series of incidents after that also.
No,
and
if it was 24, what made him wait till 27/5/26 for 2 years? Really?
No, Lordship, there were various, in fact, Lordship, I may draw your attention to the list of dates, Lordship.
Lord, can I just point out
That
one thing,
is,
my lord?
Mr. Chaudhary, just let him talk.
Lordship. Lordship, list of dates by in the petition itself. July 2024, one postgraduate student allegedly resigned, citing harassment by the petitioner. this lordship, if I may be permitted, this copy of the resignation letter is at page 17.
We are
Lordship.
not concerned with that.
Lordship. No,
I'm only concerned with the manner.
Lordship, because
Now, if the show cause notice is dated
27/05/2026.
7/05.
26.
Now, show a connection to this show cause notice and the governing body's decision of 9/9/2024.
Lordship, the connection comes because the governing body's decision started and it was a general decision and also specifically included the postgraduate students' resignation, number one.
That is the agenda.
That is there. The second was on 12th August 2024, faculty and staff members of her department gave representation against the petition. Thereafter, on 9th September, as I had mentioned, the governing body decided to remove the petitioner. Thereafter, on 5th December, the petitioner was verbally instructed to appear before the inquiry committee allegedly constituted to appear before the inquiry committee, which she did not. Thereafter, Lordship, there was one more issue that on 19th September 2025, the co-principal investigator of the DG Care project, of which she was the head, addressed again communication regarding conduct of someone else in the department. And
what rules do you follow?
we follow the AIMS rules, regulations 2019, and also the CCS rules.
So the proceedings
So-
are drawn up under which rules?
It's Lordship, I'll come to that. Now, I would draw your attention to AIMS regulations 2019, Lordship.
Where is it?
Annexure 3 at page 66. Lordship, if we go to Annexure 3, para 33, conduct, discipline and penalties. Page 66. Last para, Lordship. At para 33. Conduct, discipline and penalties. The Central Civil Services Conduct Rules 1964, as modified from time to time, shall apply to the employees of the institute. Now, if we were to read this with Schedule 2 at page 78, Lordship. Now, Lordship, if we come to Schedule 2 at serial number 1 for Group A post, in which the director can impose penalties under Rule 11 of CCS rules, except for Roman 5 to 9, which are for major penalties. But I draw your attention, Lordship.
I'm not on that.
No, I'm specifically.
No, I am with you, that the director has power.
Lordship,
Let us for the moment.
Lordship, just 1 minute. If I come to the note, authorization at page 79, Lordship, specifically it is given authorization of the director, All India Institute of Medical Science, to issue charge sheet and statement of allegations, penalties and suspension orders after obtaining the approval of the governing body, which has been done.
I am giving it to you,
Lordship,
that you have the authority in terms of the 9/9/2024 order to draw proceedings against the petitioner. No issue.
Lordship.
Now let us come to what you have drawn up.
Lordship. Now, in the show cause notice, Lordship, I'll draw your attention to Annexure 22 at page 121. Page 121 of the writ petition. Lordship, the show cause notice. Now, show cause notice regarding making unsubstantiated allegations against the institute.
Now tell me, this is a notice under Rule 14 or Rule 16 of the CCS rules?
Lordship.
That you have level some allegations, frame some charges, thereafter required her to reply.
Lordship,
Just show me that.
Lordship, Lordship, if you see para 4 of this, this show cause notice, we are.
This is nothing but an explanation call.
Exactly, Lordship.
So where is the proceeding instituted against the petitioner?
No, there is no, that is what, we are just.
Mr.
asking
Chaudhary,
in
this
fact,
is only
this
an
is just
explanation call.
explanation. There is no proceedings, there is nothing at
They
all.
cannot punish you on this.
Exactly.
I think the institute has committed a serious thing, my lord, that I must point out. My lord, my learned friend is referring to page 18 to show that it is a purported 9/9/2024 decision of the governing body empowering the director executive to take decision. So Lordship has seen page 18, same document we have annexed at page 84. It's a very serious thing, my lord. We may have to file a petition under 340 CRPC or 379 BNS. Kindly come, my lord. Now see how this paper has been fabricated, my lord. For example, at page 18, my lord, recently there was a case where a PG student of CFM department tendered her resignation.
You are reading page 18.
Page 18 of the IA, my lord. This paragraph is not there in the original. For this purpose, my lord.
From where did you get this?
Yes, page 84.
No, where did you get this, Mr. Chaudhary?
Page 84, my lord. Page 18, which has been annexed to the IA.
I know that.
Yes,
Where
page
did you-
84.
Where did you get page 83?
Yes,
and
my lord,
page
it was mailed to us.
Mailed?
Yes.
Your statement is there.
Yes, it is statement to 9. Kindly see, my lord.
No, just let me first satisfy that.
Please have
this
to
has come to you.
verify Korishu. This paragraph is not there, my lord. For example,
We got it, but how did it come to you?
it was
Change of department, no?
it was given to us, my lord.
No, where you have not said anything because these are.
That is the
I know it's a
question I
copy,
also
but
asked, my lord.
You cannot have the copy. You will have to take it to some legal method.
Page number 10, my lord.
Page number 9, paragraph 9.
Page 10, para 9.
10 para 9.
Page 10 of the writ petition, my lord.
Then there was second one.
The petitioner, if your lordships would kindly come to para 9, the sentence starting
Only on
ironically.
22/11, that is what I want.
Ah.
22/11,
Ah.
2025.
Ah.
Okay, yes.
Ironically, it's a very serious
Yes,
matter.
Mr. Bhattaji,
Yes.
there seemed to be a variance.
Lordship.
There seemed to be a variance between 84 and page 18 of your.
No, in Lordship, on the contrary, at para 9, it has been specifically given that the petitioner begs to state that despite.
Forget that, Mr. Bhattaji, forget that.
Lordship,
Now in page 18, you have brought a minutes.
Lordship,
And
Same
adding that
minutes,
paragraph.
Say, page 18 of the IA.
Aye, Lordship,
You have brought a minutes.
Lordship,
Now, the same very minutes, the petitioner says that it was communicated to her on 22/11/2025.
Lordship,
She has annexed it at page 83, 84.
Lordship,
Now, if we compare both with regard to 7/11,
Lordship,
agenda GB 7/11,
Lordship.
these materials are not here.
Lordship, in fact, she has mentioned in para 9 that she has not got it also.
Okay, Mr. Chaudhary. It is there. What has
What-
happened is,
Yes.
Mr. Bhattaji,
Yes.
what has happened is,
Para 9, my lord.
the top portion of
Ah.
page 18 of the affidavit,
Ah.
that is the agenda item.
Yes.
Absolutely.
Ah.
And the bottom portion is the decision.
Yes.
Just see that. it
No,
is-
my lord, but in the agenda portion, for example, where from they got it?
No, this is something which they have not incorporated here. This is the agenda item.
Yes, Lord.
Placed before the, you will find.
No, agenda is there, my lord, in page 84.
No.
See, please see, my lord, agenda is there.
This is the decision.
No, my lord, agenda. Agenda GB 7/11, it is there.
That is there,
Ah.
but they have not extracted this portion which was placed before the.
No, my lord, what I'm
Because
trying
you
to
see-
say is, my lord.
No, you come to the next one. 7/12.
Yes.
Tabled agenda, engagement of so and so. They have not given the agenda item here. They have only extracted the decision of the GB.
No,
Lordship,
no, my lord. No, the agenda item 7/11, according to us,
it confines to, my lord, two
No,
paragraphs.
that is the decision. You come to page 18 of the affidavit.
Yes,
You come to page.
GB is hereby apprised that at
that
the
is-
time various, no, I'm sorry, my lord.
You come to page 18 of the.
Yes, I have come.
Secretary.
It is therefore.
Decision of the GB.
Huh.
Now, this portion
Hmm.
from agenda item number GB 711
Hmm.
is extracted here.
Yes, Lordship.
This is something which they had placed before the GB
Lordship.
that they have removed from this.
No, let them produce the original
That
records.
we will have them.
Yes.
That we will require them.
Yes.
There is no issue. But now tell me, if this is an explanation call only,
Yeah.
how can it cause any prejudice to you?
No, my lord, if it is an explanation call, it will not prejudice me. But they are referring to CCA rule.
Where?
Please
If
come to the show cause notice.
No.
Page 121, my lord.
They say.
No, I have
conduct
followed.
MFSC appears to be in violation of so and so, so and so.
No, please see heading, my lord. Show cause notice regarding making unsubstantiated allegation against the institute and superior officers and conduct unbecoming of a government servant in violation of a CGS conduct rules.
Mr. Bhattchaji has submitted that this is nothing but a explanation call. We will clarify, taking a cue from that, that basing on this, no penalty under the provisions of the CCA rule or the regulations is permissible. If they have to impose any penalty upon you, they will draw up proceedings in accordance with.
In accordance with law.
Lordship, it's specifically para 4.
No,
is
my lord,
given.
let me explain.
You are therefore
Let my learned
directed
friend
to
come.
furnish a specific, detailed and evidence-based reply, which we are just asking.
Mr. Bhattchaji, again I'm asking you, this is only an explanation.
It is only.
Not a not a show cause notice instituting a departmental proceeding.
No, Lordship, this is an explanation. And specifically, it has been given at para 4. Otherwise, also, Lordship, in case it is a show cause notice, it is a part of the administrative process. But in this particular case, this is only asking for an.
Yes, Mr.
Initiated against you under that. My lord, if my learned friend is making a submission that this is not a DP, as we understand in service jurisprudence, lordship will record that it's okay. But if your lordship would kindly come to page 123, para 7. Kindly see. Accordingly,
to
you
why
are called
appropriate-
upon to again appropriate disciplinary.
Because they want to ask you why disciplinary proceeding will not be instituted against you.
No.
We will deem it in that manner.
Number one.
Huh.
And number two, my lord, if I am harassed, I live in a country where I've got certain rights, my lord. Now, if I find that unnecessarily I am being harassed, when I complain to the authority did not respond. If I write a memo to the my lord minister concerned or prime minister of the country, is it a disciplinary case?
No,
That is what the allegation is.
Now, Mr. Chaudhary, the client will have to now make a reply because you are an employee. They have asked you certain clarifications. You make these clarifications before.
That I understand. Number one, it is not a disciplinary proceeding. It's simply an explanation has been sought for. It's okay. Secondly, my lord, I was only trying to submit for your lordship's kind consideration, assuming the conduct which has been alleged is correct. Is it a case, my lord, where an explanation is called for?
Mr. Chaudhary,
I understand. Administrative authorities have the discretion. But is it not a case, my lord, where they're trying to even, my lord, muzzle my voice, my lord?
they may be if they are.
And the third and the most important is the person who has taken this initiative, my lord, the allegation are against him.
Fine.
And my lord, lordship will kindly see in another case, there's a direction by this honorable court that he will not take any part in the disciplinary proceedings. And kindly come to another order which we have annexed, my lord, at page 131. In the context of that case, my lord, what observation was made by this honorable court? Please come to 131 para 8, my lord. 131. Such action and conduct on the part of the executive director, All India Institute of Medical Science, Gauhati, in the backdrop of the litigation and order passed by
We
this
have
court.
got it. We have. I think I have also passed orders in.
Some orders in that proceeding.
Yes,
Yes.
we got it. Forget it. Now, Mr. Chaudhary, your grievance was that this is a disciplinary proceeding. the same not being instituted by the disciplinary authority
Yes.
in terms of the provisions of the regulation read with CCA rule, this cannot be proceeded with. Now, Mr. Bhattaji has come up and said that this is not a disciplinary proceeding. This is only an explanation.
Millard,
call.
I have one submission caveat to this whole thing, Millard. Lordship will keep the issue open of this, whether the director in the form as has been done is competent. That issue, Lordship will keep it open. Because tomorrow in a litigation, this question will again crop up. Because what we are trying to say, Millard, the regulation gives the power, appoints who is an appointing
What
authority.
we say is we'll record all these things.
Yes.
And we will say, have you submitted a reply to this?
There. No. That suppose no.
No. What we say is that in the reply, we will permit you to take this plea that whether the, even for issuing a show cause,
yes,
even for issuing an explanation call, the director, executive director has the power or is vested with the.
Why I'm saying so, Millard, just kindly permit me to page 879, Millard. Please come to page 79. Roman 1, last sentence. Phrases like by the order of the governing body or the president or the approval of the governing body or the president can be used on such document.
I got it. But before that, as Mr. Chaudhary has raised a grievance, we'll try to redress that also. Kindly get the get a certified copy of this minutes of the meeting.
Yes, we'll do that. Lordship will do.
We have heard you.
Lordship.
We will record
Lordship.
that but Mr. We'll dispose of the whole case.
Lordship.
As agreed to by the learned counsel for the parties, the writ petition was taken up for consideration. Also, Mr. D.S. Bhattaji, learned counsel representing the AIMS authorities at the outset has submitted that the show cause notice dated 27/5/2026 did not have the effect of instituting a departmental proceeding against the petitioner. He submits that the said show cause notice was issued only for the purpose of was for the purpose of receiving an explanation from the petitioner with regard to the circumstances noticed against her and recorded in the said show cause. He submits that in the event a departmental proceeding is to be so instituted, an appropriate show cause notice / memorandum of charge would be issued to the petitioner in the manner prescribed under the provisions of the regulations holding the field, read with the provisions of the CCS (CCA) rules 19 year 2020 to 2001 21. Full stop. Mr. K.N. Chaudhary, learned counsel for the senior counsel for the petitioner, submits that the basis of challenge to the show cause notice in the present writ petition is to the effect that the director, in terms of the executive director, in terms of the regulations holding the field, is not the appropriate authority to institute proceedings against the petitioner. He submits that the proceedings, if any required to be instituted, he submits that any disciplinary action required to be taken in the matter is to be taken only by the governing body of the institution. Accordingly, he submits that the plea taken by the petitioner that the executive director even was not empowered to issue a show cause notice, ask the petitioner to submit an explanation, was not permissible. But the learned counsel for the parties at some length. Also, Mr. D.S. Bhattaji, learned counsel for the respondent, for the AIMS, respondent AIM has submitted that the governing body in its meeting held on 9/9/2024 had empowered the director executive director of the institution to take appropriate action with regard to any allegation of misconduct arising against any faculty, oblique officer, oblique staff of the institute. Accordingly, he submits that the show cause notice is permissible to be so issued. So, the Mr. Ken Chaudhary, learned counsel for the petitioner, has, however, disputed, has by drawing attention of this court to the copy of the minutes of the meeting of the governing body held on 9/9/2024, which were furnished to the petitioner, and the copy thereof as annexed in the interlocutory application, has highlighted that there is a variance in the same. So, in view of the above, Mr. D.S. Bhattacharjee, on the next date of listing, shall furnish a certified copy of the minutes of the governing body meeting dated held on 9/9/2024, as is available on records.
And my lord, one more point, my lord. Since appointing authority has been defined in the regulation, whether appointing authority can delegate that power. Appointing authority is the governing body. That's a point, my lord. Maybe
That is taken by those words in the name of and in favor of.
Well, I'm just trying to keep the issue open, my lord.
In our rules, this is decided. In our rules, it is by the governor. But no order is issued by the governor. It is by the titular governor. That's the minister and the secretary in the name of the governor and by the order of the governor. That's all. But your grievance was that this is a departmental proceeding. Now that it's not a department.
What is also not ascribed to, no?
Oh, Lord, that point was, my lord, no, I appreciate, my lord, because when it comes to, my lord, state government rules, rules of executive businesses clearly provides. But here it is not. But the question is, my lord, when the regulation says X is the appointing authority, can that appointing authority delegate its power? That's the point, my lord.
We will see.
That point may be kindly taken.
Because that there is a recent decision of my Lord Justice Dr.
Dipankar
Dutta. The issue there was a authority below the
appointing
authority had issued the show cause. Matter traveled to the Supreme
Court.
Then he said, he has made a very fine distinction there. He said, while issuing the notice, the requirement under 311 is not to be proved, is not to be satisfied. But while imposing the penalty, nobody other than the
appointing authority. Absolutely. But, my lord, there is one thing, my lord. P.V. Shastri's case, Supreme Court had said that Article 311 do not prescribe that it is the appointing authority who is competent to take disciplinary action. However, if there is any rule, however, if there is any rule under proviso to Article 309, then it has to be by that competent authority.
Here it is here. And here it is.
Here, my lord, it falls in that category. P.V. Shastri.
No, the P.V.V. Shastri, I think, has been taken care of by my Lord Justice, has been also referred to by my Lord Justice. But just find out that judgment.
I'll do that. No, what I'm saying,
please need to list this matter again on
8.
Kundina Pari.
13 alagi.
No. 3 তারিখ আগত দিয়া। No, মই দিব লাগিব। Mr. Chaudhary.
My lord, other than 30, my lord, any date.
Sorry, it's really tied up. Can you have it on 17th or 18th?
No problem.
On 18th.
Otherwise, my lord,
This I'll not be here.
28 was a very auspicious day.
28 तारीख क्या?
It's Lord's birthday.
We'll have it on 18th.
18/8/2026. Interim order passed earlier to continue till the next date of it. You just get that copy.
We'll get it.
But this is the agreement.
This is the agreement.
We have noted here, that will not be there in the order, but I've kept it for my own notes.
Lordship, interim order now is infructuous actually because it is just a.
So that is a formality.
That's
It will be a formality.
Delay.
Much obliged, Lord.
But my apologies, my lord, we prepared the written submission. But the thing is that my lord, there are some correct clerical mistakes and page numbers are to be inserted. But I'll be able to file tomorrow morning, I'll file it. My lord. I'll give a copy to my senior. My lord.
On the prayer of the learned, you have also filed?
Yes, well, we have already. Yes, well, I have got a copy. My lord.
On the prayer of the learned council for the parties, registry to list this matter on 30, khali ito lobo karna. 37.
Deeply approved. 30. Much obliged.
My lord, can it be fixed at 2 p.m. if possible? Otherwise,
You come, we'll take it up too early.
my lord.
Deeply approved.
No more hearing required, only.
No, not hearing, only because my lord is just
If you can give it to me a day in advance, so that that day we can pass the order.
my lord, my lord.
My lord, tomorrow morning, I'll just hand over
Only
it to.
tomorrow morning. I'll not look into it otherwise also.
All right.
Give it on 20 kitya fix koilo?
30.
Give it on 29 p.m.
Fine, fine.
Sufficient time.
Highly
Yes.
As per last affidavit, they have filed, madam.
Now, what happened to the proceedings? That proceeding is still pending.
Yes, madam. There is no progress, madam.
Seal cover.
Not yet, madam.
You have not kept it in seal cover.
Seal cover, they have not done, but
Then-
lordship, one post they have kept reserved, lordship. Page 168, madam. In specifically against his name, lordship.
So you will have to hold a review now again.
Yes. Once he is, acquitted from the DP or criminal lordship, his case will be considered by the review.
Criminal case also, charge sheet has been filed.
Pending, yes, that's
Filed.
So that is the also. If I may be. If the ad hoc promotion, madam. No, no.
We don't have that concept here.
In a BC Sotubedi, madam.
You see,
Sotubedi case, madam.
Supreme Court.
Yes, madam.
But because that there was a provision in the notification for giving an ad hoc promotion.
No, madam. Para 8, madam. Madam.
What is the age of the petitioner?
Is the 53, madam. It will take time in a criminal size, madam. Para 8, madam. Here, madam, the about charge, madam, considering the madam, notification passed by the central government, madam, has given the madam ad hoc promotion, madam.
This will be contrary to Janaki Raman.
I know, madam.
Because they have not taken any policy decision.
Yes, madam.
The only thing we can do is that we can dispose of the writ petition saying them that holding that on the proceedings concluding, if you are given a clean sheet therein,
Yes, obviously, madam.
they will hold a review DPC within a month thereafter.
Yes, madam.
And then if you are entitled to promotion, you will be promoted with retro. That's all.
And DP should be madam, completed in a time frame, madam.
What is the stage of the DP?
DP lots of it's going on. I have to take the exit.
Just have the telephonic instruction. Can you have a?
Yes, and last hearing. No, even if lordship passes an order directing the authority to complete the DP within a specific period, lordship.
No, I don't want to do that because what is the
criminal proceeding will review.
I'll not put in any time frame.
At this stage, lordship, I think that. But DP is concerned only, madam. No, DP is not the only concern. Criminal proceeding is also pending, lordship.
Delivery. Third, the learner counsel for the parties at length. Hearing concluded, registry to listers met on Friday by slip query for delivery of orders. Do one thing, just
Yes, that I will take. Lordship, one more thing is there, Lordship. On last occasion, Lordship, it was on 6/3/2025, last DPC, Lordship. Therein, Lordship, his case could not be considered because of his failure to submit the APRs.
it doesn't make any difference.
One, Lordship, and secondly, ACR for the suspension period.
Okay, fine. ACR, who is making that ACR for the suspension?
I mean,
ACR, I cannot.
I mean, one order has been issued, Lordship.
I have filed my already, man.
You do one thing.
I'll take the status, Lord.
Whatever it is there, once he is exonerated, give him everything.
Yes. Authority will consider.
Or consider if he is found fit, give him everything. From the date he was appointed, notionally till the date he is there.
That subject to his acquittal from in the.
Oh, naturally.
Obviously, man.
Clean chit. Not only acquittal, clean chit. And give me that particular, what is the stage of that disciplinary proceeding?
Yes, Lord. On next date, Lord. Arikitiya fix korila.
Friday.
But Miss G. Goswami, senior counsel, assisted by Mr. H.I. Chaudhary. Also heard E. Bora, government advocate, appearing for the state. So, the petitioner in the present has prayed for a direction upon the respondent authorities to regularize his services against a grade 4 post in the establishment child development or Kola ICDS project, and also for release, for authorizing to him his salaries with effect from July 2007 till as projected in the petition, the respondent authorities had set up the establishment of the CDPO or Kola ICDS project in the month of July 2007 in a premises owned belonging to the elder brother of the petitioner. So, as the said establishment was being set up therein, a requirement exists therein for a grade 4 staff, it is projected that the elder brother of the as well as people of the locality had made a demand to appoint the staff. So, accordingly, it is projected that the petitioner was permitted to work as a grade 4 staff in the said establishment since the date of its establishment. However, no formal engagement order was issued to the petitioner. So, the engagement of the petitioner in the said establishment is thought to be established by certificates issued by the respondent authorities. However, in the sets of by the respondent authorities envisaging therein the services rendered by the petitioner said established in the said establishment. So, as the petitioner was continuing in his said service, the post of a post of a grade 4 post came to be put up for recruitment wide an advertisement date 24/3/2014. Also, the petitioner submitted his candidature against said advertisement. However, the selection, however, the recruitment process was not taken to its logical conclusion. Also, the petitioner thereafter submitted an application on 6/9/2016, praying therein for consideration of his case for appointment for regularization of his services. Also, the said advertisement was followed by a further said representation was followed represent 31/10/2020, wherein the petitioner had projected that he was working, had prayed for a regularization of his services, projecting that he was working in the establishment of the child development project, Procola ICDS, without any wages honorarium, only with the hope of that services be regularized against vacant post available, vacant grade 4 post. So, the said representations were further followed by further representations on the same line. It is further projected in such representations was forwarded by the CDPO to Procola ICDS project to the Director, Women and Child Welfare, Assam. However, no orders came to be issued regularizing the of the person. It is also projected in the that as and when higher authorities required production of have required the particulars of the persons working in the establishment of the child CDPO, Borkhola ICDS project, such particulars as forwarded also contained a reference to the petitioner, who was reflected therein to working temporarily as a grade 4 staff on voluntary basis. The petitioner further projects that a recruitment exercise was carried out in the matter in the year 2023. And where have you stated that you have stated, sir? Projected that petitioner has further projected the grade 4 post as available in establishment of the establishment where he was working, having been put up for recruitment, wide and was put up for recruitment the month of March 2023. However, the petitioner having crossed the upper age limit, he was not in a position against the said post. Also, accordingly, the petitioner's case for regularization of his services not so considered by respondent. The petitioner has instituted present writ. Ms. G. Goswami, learned senior counsel, after by reiterating facts and circumstances noted, has submitted that the petitioner has been rendering his services in the establishment of the CDPO Borkhola ICDS project since July 2007 without any break. She submits that the continuation of the petitioner in his was on of the need existing in the establishment a hand to perform the duty that's to in absence of a regular incumbent. She submits that in view of the long service rendered by the petitioner and in during the course of which he had also become overaged for being for applying against any other government post up for respondent authorities were required to regularize the services of the petitioner and thereby regularize the service. Ms. Goswami has submitted that although no order was issued, no order was issued towards engaging the petitioner here. However, from the certificates issued to the petitioner by the respondent authorities, the rendering of service by the petitioner in the said establishment would be set at rest. Full stop. Ms. Goswami has further submitted that even in the particulars of the employees forwarded from time to time by the authorities of the said forwarded from time to time by the CDP of Borphala ICDS project to the departmental authorities, the name of the petitioner was reflected therein. So, in the above background, in the above premises, Ms. Goswami submits that the respondent authorities submits that a direction is called upon to be issued to the respondent authorities to regularize the services of the petitioner. Ms. Goswami further submits that the petitioner having been rendering his services from July 2007 and such services being so rendered by him with the knowledge of the respondent authorities, the petitioner could not have been, petitioner was required to be paid wages for such for the services so rendered by him. He submitted that the services being rendered by the petitioner is in the form of a forced labor, and which is clearly in violation of the provisions of Article 23 of the Constitution of India. Accordingly, she submits that the respondent authorities are required to accordingly, she submits that this court would be pleased to direct the respondent authorities to authorize to the petitioner his due wages for the period of service rendered by since July 2007. For contrast, Mr. D. Bora, learned government advocate appearing for the state respondent, submitted that the petitioner's engagement, the petitioner was never engaged in the establishment of the CDPO ICDS Borphala ICDS project by a department, by any authority of the department. Mr. Bora submits that from the materials available on record, it was found that the petition was rendering voluntary service in the said establishment. Also, he submits that in the recruitment exercise initiated in the year 2023, in pursuance to the recruitment exercise initiated in the year 2023, the vacant post of grade 4 post that was available in the said establishment has already been filled up, and incumbent is working against the said post on a regular basis. Also, Mr. Bora further submits that the petitioner herein not being engaged by a departmental authority and he not serving the said department under instructions from the departmental authorities and his services being voluntary in nature, comma, no claim of for wages would be maintainable and the would be maintainable. So in the above premises, Mr. Bora submits that the claims made in the present writ petition would mandate an interference from this court. I've heard the learned counsel for the parties and perused the materials available on record. Full stop. The petition is found to have been working in the establishment of the CDPO, Korpala ICDS project with effect from July 2007. There is, however, no order engaging the petitioner by the departmental authorities for discharge of such, engaging the petitioner in the said establishment. However, from the certificates as well as particulars of the employees of which were being forwarded from time to time by the respondent number 3 to the other higher authorities, respondent number 4 to the higher authorities, it is found that the petitioner, it is seen that the petitioner was in fact working in the said establishment since July 2007. However, what is to be noted is that in the certificates brought on record in the writ petition as well as in the list of employees being forwarded by the respondent number 4 and respondent number 4 from time to time, comma, the petitioner is found to have, petitioner is denoted to have been rendering services in the said establishment on voluntary basis. So, as noticed next, as noticed herein above, the petitioner had joined his services only with effect from July 2007. Even if it is construed that the petitioner was so engaged on casual basis, comma, in view of the recent decision of the Honorable Supreme Court in the case of Sukhendu Bhattacharjee and others versus State of Assam and others, box 2026 INSC 523, comma, no direction can be issued for consideration of the case of the petitioner for regularization of his services, inasmuch as the Supreme Court in the said decision had categorically laid down that the regularization of casual / muster roll / work charge employees would services of regularization of the services of casual / ad hoc, casual / master roll / work charge employees would be permissible only in cases of such employees who were so engaged prior to 1/4/1993. The petitioner herein, having admittedly been engaged after July, only having been engaged only in the month of July 2007, comma, the petitioner, in view of the decision of the Honorable decision of the Honorable Supreme Court, comma, would not be entitled to have his services regularized. So accordingly, the prayer of the petitioner made in the present petition for a direction upon the respondent authorities to regularize his services would not mandate an acceptance from this court, and the said prayer accordingly stands rejected. Also, having drawn the said conclusion, this court would now examine the further prayer of the petitioner for being authorized his due wages for the period for the services rendered by him from July 2007. Also, although the respondents have projected that such service of the petitioner was voluntary in nature, comma, this court finds that while this court finds that the petitioner had continued in his services, was working in the establishment of the CDPO, ICDS, Borkhola ICDS project with effect from July 2007, and such engagement of the petitioner herein in any capacity was to the knowledge of the departmental authorities. It is also found from the pleadings, from the affidavit filed by the respondents in the matter that such aspect of the matter is also admitted to by the respondents. Also, the petitioner having rendered his services, even if it is to be deemed that such services were rendered on voluntary basis with effect from 2/7/2007, the such services being rendered in a government institution, the petitioner cannot be denied his due wages for the period of service so rendered by him. This court is of the considered view that in the event the petitioner is not authorized a wage for the services rendered by him, such services would tantamount to be forced labor and would be in violation of the provisions of Article 23 of the Constitution of India. Accordingly, this court, having found the petitioner to be in service with effect from having found the petitioner to be rendering services in the establishment of the CDPO ICDS project, CDPO Borkhola ICDS project with effect from July 2007, this court holds that the petitioner is entitled to a wage for such services rendered by him in the said organization. So, accordingly, the petitioner is directed to submit a representation before the competent authority of the department through the CDPO ICDS project Borkhola, staking a claim for being authorized wages for the period of the service rendered by him with effect from July 2007. The competent authority of the department on the Director, Women and Child Development, competent authority to the Director, Women and Child Development. The Director, Women and Child Development, on a receipt of such application, a representation from the petitioner, shall consider the same by also examining the contemporaneous records to ascertain the exact period of service rendered by the petitioner in the said establishment. So, thereafter, the Director, Women and Child Development Assam, shall pass a speaking order and therein determine the wage required to be paid to the petitioner, either on a daily basis and or on a monthly basis, and thereafter computing the areas of such wages receivable by the petitioner for the services rendered by him for the period of service as determined in his case with effect from July 2007, released to the petitioner the areas thereof. So, if the petitioner is found to be continuing in his service as on date, the petitioner shall be paid his due wages as determined by the Director, Women and Child Development Assam, till the petitioner services are so received by the respondent authorities. So, with the above observations and directions, the present writ petition stands disposed of.
Yes. We need some time to confirm it, whether this letter that today my learned senior has.
Design your records. If
But
somebody
that-
can
that's-
give you this.
That is why we are under process of checking it, Miller.
On the
Actually,
behalf of Dr. H. Chamuha, learned, Mr. Anagalika. Give me that letter.
Mal.
Mr. A. Chakraborty, Mr. P.K. Roy, learned senior counsel appearing for the respondent number two. Has placed on record a written instructions received by him from the Assistant Provident Fund Commissioner, bracket legal, dated 21/7/2026. On a perusal of the said instruction, it is seen that the petitioner had deposited EPF dues only amounting to only rupees 12,84,27,032. Also, the petition was the PF authorities had assessed the area dues of the petitioner for the period with effect from 4/20/2015 to April 2015 to 10 October 2016 as rupees 20,54,14,712. So, it is accordingly seen that the petitioner had not cleared the said dues, although there were undertakings given before this court in the present proceedings of clearing the said amount expeditiously. A copy of the said communication has been furnished to Ms. Dr. A. Chamuha, learned counsel for the petitioner. Mr. Chamuha submits that he be granted further time till 29/7/2026 to complete his instructions and apprise this court with regard to the actual areas now required to be cleared by the petitioner in terms of the notice order dated 6/9/2018 issued by the Regional Provident Fund Commissioner. First off, registry to list this matter again on a copy of the instructions furnished by Mr. P.K. Roy, learned senior counsel appearing for the Provident Fund authorities, is kept on record and marked as X for the purpose of identification. You get your instructions. Miss, as they is present for the respondent number 6.
But you was fixed the date.
29.
Right.
And there are undertakings given 1 month. Now we'll have to impose cost because these are public money. These are money for the welfare of the staff. And you are sitting over the issue. Now we will impose heavy cost on you. Maybe one green bus. Yes.
Yes, well.
Done. Wait. Oh, forget you don't start accepting.
No, my lord. From the Defense Ministry that has already been released, my lord. That is now pending in the, they said that audit authority. My lord, kindly see page number 5, my lord, of my instruction. Paragraph 6 and 7 is important, my lord. Page number 9 is, my lord, leave encasement certificate. All has already been sent, my lord, to the audit authority, my lord, for releasing of the money, my lord. Defense Ministry has completed their task, my lord.
This was in 21.
But this one is 25, my lord, 6th August 25, my lord. Kindly see that page number 5, my lord. That has been closed, that some disciplinary proceeding was pending.
Okay, then what? Who is appearing for the audit authorities? You are only appearing.
But here, yes, my lord, but Here, my lord, the party is the Ministry of Defense, my lord. Defense Secretary has already passed the order by order,
Is
case
that
number
employee
5.
under the defense secretary?
Yeah, Defense Secretary.
So they are responsible to release it. They cannot just shirk their responsibility.
My lord, they are taking,
where will- where
as
will
per
this
my
come?
instruction, my lord, on 12, as per my instruction, my lord, recent instruction today, on 12th of July, my lord, they have released the amount.
To the account of the
And but that is my oral instruction, my lord, on 12th of July, my lord.
Ms. A. Gain, learned CGC appearing for the respondents by referring to the instructions received by her in the matter has submitted that the determination with regard to the quantification of the amount receivable by the petitioners against a leave encashment benefit has already been done. She submitted that on 12
July, my lord.
12 July 2017. The said amount has already been deposited in the account of the petitioner. However, Mr. S. Bora, a learned counsel appearing for the petitioner, submits that no such amount has been credited to the account of, submits that he has received no instructions from the petitioner with regard to.
No, today instruction is that no amount has been.
Oh, Mr. Bora submits that no amount, with regard to the leave encashment benefits of the petitioner has been credited to his account. So, in view of the above position, Ms. Gang on the next date of listing shall place on record the documents envisaging the disbursement of the leave encashment
Yes, my
benefits to the petitioner hearing. So, registry to list this matter again on 31/7/2026.
31/7.
Okay.
Past the present.
Any similar cases decided? You know about it?
No.
One need appeal, this is the Bongaigaon matter. And another is South Salmora.
And yours are from?
Bongaigaon.
Same order. Oh, that was taken up on appeal also.
Appeal, Lordship. Bongaigaon one is appeal. Same ground, my lord, that petitioner have. Lordship. Appointed by the villagers.
There is no system actually, that is why, my lord, they are performing their.
Dismissed. I'll just go through it and then pass the order. Dismissed. Yes.
No seal cover, Lordship, but it was considered and it has been reflected in the minutes that because of the pending DP and lack of ACR and APRs, his name was to be placed in the subsequent DPC.
What happened to the, you have a criminal case also against you?
Yes, my lord, bribery.
Is a charge sheet filed there?
My lord, I have to take inspection, my lord. But my lord, in so-called proceeding, my lord, disciplinary proceeding, after filing the reply.
No
action has been
proceeding.
taken, my lord.
Mr. Deka, in those circumstances, get your instruction whether there is any proceeding in the
Criminal proceeding.
criminal proceeding.
Status of it.
We will ask them to complete the departmental proceeding within a time frame. You
My
also
lord.
participate.
My lord,
And if there is no charge sheet in the criminal proceeding, there will be no bar. They can
Yes.
consider your case for promotion.
Yes.
If they have not kept it in seal cover, they will have a review DP. So that's
Yes.
much only I can do.
yes,
for you. When?
first week of August, my lord. Fifth or
Pardon me, tied
no,
up.
motion matter, my lord.
Motion. On the prayer of the learned council for the parties registry to list this matter again on 7/8.
Lordship may kindly grant me some other time, some little more time. I'll bring it on affidavit.
Just
Please.
give your instructions, Mr. That will do.
No, they have given us paragraphs comment, so.
No, you give it in the form of a written instruction. That will, you get a written instruction. Why keep this matter pending? Giving you filing an affidavit, I'll have to give you 3 more days. So then why? Unnecessarily, this will occupy space.
So although with the liberty, if within the time frame, I can file an affidavit.
You want to file, we have not restrained you, or get a written instruction. That's all.
I'll take instruction.
All right.
Deeply obliged.
Yes, what happened? You all were abandoning this court in the morning today. Nobody was there. Excise, PHE, matters were there. Nobody was there.
I was just about to come, my lord. On my
You
way,
were
my
about
lord.
to come, but you reached now.
Yes, my lord.
Yes, what is this? What has happened?
I have received a communication, my lord, that amount for sanction was communicated to accountant general. My lord. But then,
sanction?
my lord, yes, my lord, what happened, my lord,
So, anything more is required. We can close the matter.
Within speaking
Okay.
time,
Uh,
specific time, madam.
the heard Mr. SZB Atlas, Learned Counsel for the petition, also heard Mr. I. Thakur, Learned Standing Counsel, PHC Department. The petitioner in the present petition has prayed for a direction upon the respondent authorities for authorizing to him his area salaries for the period What is this areas?
My lord,
For the period, the areas is for the period?
my lord, period, from, 01/10/1989 to 30/04/2022.
You were a
Master Lord.
You are now regularized.
No, already retired. Without regularization.
For the services rendered by him, area salaries for the services rendered by him as a master role labor with effect from
Effect from, 01/10/1989
01/10/1989 to
30/04/2022.
so and so, paisa na? Amounting to rupees 2,06,688 pura words of the Full Mr. I. Thakur next. Learned Counsel, full stop. Mr. I. Thakur, Learned Counsel for the petitioner, for the Learned Standing Counsel, PHC Department, has placed on record a communication dated 23/2/2024 issued by the Under Secretary to the Government of Assam Public Health Engineering Department to the Accountant General, bracketed A&E, Assam, convey the sanction of the Governor of Assam for trial of area salary in respect of the petition. Vasanta Kumar of the petitioner herein for a total amount of rupees 2,06,688. It is submitted that the said amount now being sanctioned by the government, would be disbursed by the Accountant General A&E, Assam, within a short period of time. Also, in view of the fact that the area salary claimed by the petitioner hearing has already been sanctioned by the government in the Public Health Engineering Department, and the such sanction being conveyed to the Accountant General, bracketed A&E, Assam, the said amount would now be required. Said amount on being further processed would be required to be disbursed to the petitioner in his bank account. So accordingly, the Accountant General bracketed A&E Assam and also is directed to accord necessary approval from its end to the sanction already granted for release of the arrears salaries of the petitioner amounting to rupees 2,06,688 within a period of 1 month from the date of receipt of a certified copy of this order. Also, thereafter, the said amount within a further period of 1 month shall be credited to the account of the petitioner in the manner mandated for credit of such amount in an account of a employee working or mandated liquidity. With the above observation and direction, the present writ petition stands disposed of. A copy of the communication dated 23/2/2024, furnished by Mr. I. Thakur, is kept on record and marked as X for the purpose of identification. Yes. What has happened here? Any instruction?
Here, my lord, I've just been, my lord, verbally informed that at the relevant time there was a pending DP, my lord, but I want written instructions. I will, my lord, next date I will file an
That
affidavit.
DP has been dropped.
Yes, that has been set aside, my
Set aside by this.
set aside, and page
Is there
38, my
any
lord,
other DP?
governor has
Any other
passed the order.
It is dropped. There is any other DP against him, which Mr.
Since 21, my lord, I am claiming, my lord. Whether any seal cover or anything,
There is no DP now.
I'm being told, my lord, something is there, my lord, some proceeding is there. I want to.
Friday.
whether in this
Friday.
loss.
Can it be on Monday, my lord?
Monday.
Some-
Okay.
Monday ki man
On the prayer, 27, you are here?
Yes, yes.
On the prayer of Mr. I. Thakur, Learned Standing Council, PHC, Learned Standing Council Forest Department. Matter stands adjourned today to facilitate Mr. Thakur to place on record written instructions received from the competent authority of the department with regard to the reason as to why the petitioner has not been granted his due promotion to the rank of Assistant Conservator of Forest. Also, registry to list this matter again on 27/7/2026. No further adjournment shall be granted in the matter.
Public. From morning, my lord, I was sick.
Yes, madam.
My lordship, I have asked my client and the petitioner has informed me that yesterday in the block office, he has signed for the Udali waste sign and the Saiful Islam has signed for the Bamunga waste payment. So for the waste payment, in front, both of them were present in the block yesterday and he has signed for the Udali waste payment and Saiful Islam has signed for the Bamunga waste payment yesterday, my lordship. So as
But
of now, he has joined or not?
That you
Yes.
don't know.
Lordship,
Because them being made partners,
yeah.
ma.
my instruction is that the Saiful Islam, the other person, he has joined his place of posting already.
Odali.
Yes, Odali.
So you have to go to Bamungaon now.
Yes. Or that's my lordship, may I pray that in this petition, I withdraw and I file it more
Fine.
by making him a party because I've already
Do
asked.
that, then only we can
Yes.
do something.
Withdraw.
And you have not even submitted a representation also.
Yes, because my lordship immediately
Immediately.
one after another transfer. my
Okay.
lordship.
Heard Ms. S.G. Burwa, Learned Counsel for the petitioner. Also heard Mr. A.K. Ghosh, Learned Standing Counsel, Panchayat and Rural Development Department. The petitioner in the present writ petition has presented a challenge to an order of transfer dated 13/7/2026 by which the transfers ordered in respect of the petitioner and one another was modified. So, Mr. Ghosh, A.K. Ghosh, Learned Counsel for the respondents had submitted that in the event this court proceeds to consider the contentions of the petitioner and interferes with the order dated 13/7/2026, the same would have the effect of disturbing the services of one Pranab Kumar Mek.
No,
It is no malicious.
so
I
few.
Saiful Islam would have the effect of disturbing the transfer and posting affected in respect of Saiful Islam, who however is not made a party respondent in the present petition. So in view of the above submissions of Mr. A.K. Ghosh, Ms. S.G. Borua, learned counsel for the petitioner, submits that she be permitted to withdraw the present petition with liberty to refile the same after rectifying the errors noticed herein. So prayer accepted, the present petition stands stands dismissed on withdrawal with liberty as read.
My lordship, hello.
You are not challenging 7. You want to go to
No.
Azerbaijan.
No. I want to stay in my
But-
place.
But you have not challenged 7 also. Yeah.
My lordship, that is state because in Pranab Kumar make his order is state, my lordship. Yes.
So Fuel is coming to your place now.
Yes, only Sofuel and me now.
Now,
Oh.
so your 7 also you will have to make a challenge. You have not made a challenge with regard to 7. 7th order.
7 order. No, that order is modified because if I go to that,
Okay.
yes, because there are many petitioners also
Okay,
in that order. Okay.
May it please your lordship.
Oh, yes. What happened?
We have given there was the issue was basically could have been resolved. What has happened? No, he has been given. Initially, there was a letter issued to him, your lordship, stating that whether he is inclined to accept the headship because the other persons they were given, one did not accept, one accepted. He was also provided. Then this is the order, and and then the reply actually created a problem. He stated, your lordship, that also I am providing. So they have again placed it before the GB. Now, because of the holidays, GB has not taken up. I have personally stated that they will accept, issue the appointment letter to him, but his letter, that some problem may create, that's why they were not very sure. Because he stated to restore me in the advisory role and this part, actually they are appointing as head, your lordship. That is where
He has, forget the first part.
he said, I accept the decision to restore me.
Restore me to the.
They are issuing an appointment letter, your lordship, because he cannot be restored with retrospective effect.
Restored means that he is, this is English.
Then your lordship can do one thing. My suggestion.
We will dispose it of,
Dispose
saying
it of.
that
Yes.
you will pass appropriate orders.
Yes.
Accommodating him in the advisory role of the college affairs as well as the head of the department within a period of 1 week.
Yeah. Lordship may put it a little bit more because they're having the
Mr.
because
I'll
they're
put-
putting
I'll put it
placing
in a
before the
different
G.
manner. I'll
Yes.
put it in a.
Lordship can dispose it.
We'll
I have
not
no-
dispose it off, we'll keep it.
Yeah.
Heard Mr. S. Sharma, learned counsel for the petition. Also heard Mr. Y.S. Manna, learned counsel appearing for the respondent's number. Respondent's number.
Respondent, your lordship, I am appearing for respondent
Sharma,
number
what do you see?
3434.
Respondent number 3 and 4. So,
Five also.
Mr. Manna has submitted that after due deliberation of the matter, the governing body of the college had accepted the clarification submitted by the petitioner and accordingly had resolved to withdraw the ban imposed upon the petitioner for being included in being appointed in an advisory role in college affairs. So, further, the governing body had also resolved that the petitioner can now be given the responsibility of the head of the department. So, the said aspect of the matter was communicated to the government, to the petitioner, via a communication dated 8/6/2026, issued by the principal of the college in question. So, the petitioner, via communication dated 10/6/2026, although had in the first paragraph of the said communication projected that there was no banning order in existence, or if there was any, the same had come to an end while RUSA, RU as an honor, had visited the college on 28/2025 and submitted a report, comma, in the second paragraph of the said communication, he had accepted the decision of the governing body to restore him as in the to restore him in the in a role of an advisory capacity in the college, as well as to allow him to hold the charge of the head of the department.
No, he is not charged. He will be holding the post of head of.
Hold the post of head of the Department of Education in the college. The petitioner,
Lordship can give 2 weeks time. In the meantime, it can be.
no, the petitioner, having accepted the governing body having resolved to allow the petitioner to allow the petitioner to resume his role as in the advisory role in the affairs of the college, and also to allow him to hold the post of HOD, and the petitioner having accepted the said proposal made in this connection, the principal of the college would issue appropriate orders
Yes.
incorporating the said acceptance of the petitioner and issue the same to the petitioner within a period of 2 weeks from today.
Lordship.
So, registered to list this matter again on 17/8/2026.
Lordship can dispose it off because we will issue it.
This is much ego. There seems to be a big ego here.
No, no, I have talked to him.
I know.
They will
That's why
issue
it
it.
has
Other,
happened. But
No.
there is an ego. Let us
Lordship, I'll.
let us not allow that ego to go. Today not dispose, next day dispose, we are
Yes.
clear with that. 17/8/2026. Mr. Manna shall place on record orders issued in this connection by the college authorities on the next date of effect.
They will issue it, Your Lordship, because it is already placed before the GB. GB is sitting in the
Copies
first week of
the,
August.
Communication dated 8/6/2026 and 10/6/2026 are kept on record and marked as ex-colleague for the purpose of identification. Why colleague? Why colleague for the purpose of identification?
Actually, I have accepted Your Lordship's proposal. That is why I tried to push it off. And I wanted the matter should end. It's
Mr.
no use
Mannan,
keeping it.
Mr. Mannan, we know that you can do it. That's why we asked. Otherwise, we would not.
No, they will do it. Now
No, no, no.
I am.
They do it or not, I don't know, but I know that you can put the message across.
No, I have already.
You can ask them to act in a
No, they say
lawful
that
manner.
because of this, we have placed it before the GB again. And I said, you issue the order and finish it off. Say that with this because of the, I think, summer vacation, GB will be sitting in second week of August. They will issue it.
Kitted issue date of 70, all of this. 21.
Yes.
Done?
Obliged. Yes.
Last about 12 months, my lord, another suspension. The extending, my lord, it should be on the reason, there is no reason, my lord. Simple, grave offense, and for that, my lord, your lordship will find. Page. First, my suspension, my lord, page with effect from 10/9/25.
What is the stage of the department proceeding, Mr.
That only, my lord, that they have been asked to appear. Appear.
No, inquiry officer appointed.
Appointed, Lord, on 15/10, Lord.
And same thing, my language.
2025. What is he doing for this whole period?
So
More
was
than
not-
2, 7, 9 months.
Not 10 months,
So
12
was
days.
issued, Lordship.
Huh?
So was issued, Lordship.
Ah.
Submitted a reply, Lordship.
Then inquiry?
That was not satisfactory, Lordship.
Okay, inquiry officer appointed.
Yes, sir.
Appointed.
Now, how long will you continue with the inquiry?
Was not.
Years together, 5 years, 6 years, how much?
Obtain instruction, Lordship.
You are making him earn money without discharging any duties. That is also not. What is the allegation against you, Mr.?
5,000.
5,000.
5,000 rupees.
Red-handed.
Oh, that trap.
Trap.
What happened to the criminal case? Any charge?
No, nothing. Very preliminary step.
Mr. A. Chakraborty, learned counsel for the petitioner. For the respondents, the government advocate appearing for the respondent. For heard Mr. H.R.H. Chaudhary, learned senior counsel, huh? Mr. A. Chakraborty, learned counsel for the, learned government advocate appearing for
All
the
the respondents.
respondents. Shall on the next date of listing receive a positive instruction, receive instructions from the disciplinary authority of the petitioner as to the period which would now be required to complete the departmental proceedings instituted against him. It is to be noted that the departmental departmental proceedings are to be concluded within a period of 6 months. 6 months in the terms of the manual, Mr. Das? In terms of the manual, it is 6 months.
No, that is not mentioned especially.
No, there is some.
That to review.
No, the departmental proceedings in terms of the manual, it is 6 months, I say.
6 months.
6 months is to be concluded within a period of 6 months. So it is seen that the inquiry officer in the present matter was appointed on 15
10 to
15,
25.
15/10/25.
15/10. No, 15/10 is your suspension. When
No,
was the inquiry officer appointed?
No, 15/10 is the my lord, inquiry officer.
Inquiry officer.
Page 31.
Stated in our affidavit.
Suspension is also 15/10.
Yes. With effect from
15/10/2025. However, they said proceedings have not come to an end. So, Mr. Chakraborty shall receive his instructions in writing from the competent authority of the disciplinary authority of the petitioner and place the same before this court on the next date of listing. Registry to list this matter again on 30/7/2026. We see, we fix a time frame. They'll finish it. If not finished, you will be fixed.
10 months, more than 10 months already gone.
Charge is also mentioned.
No,
But here they have given you a show cause.
So, yes, that's not done.
No, bless.
Lordship, here the thing is that affidavit has gone for fitting on 16/7, but we haven't received
Where
it.
is that 3,000 rupees deposit?
Lordship, that was supposed to be filed along with the affidavit. Lordship, may please grant me a week's time.
Even after imposition of cost, the affidavits are not come.
Lordship, we have sent it on 16/7, Lordship.
Okay, who is the authority who has not given it?
Lordship, now they have.
Now, this order was passed on 22/10/2025. And you have sent the affidavit only on 16/7.
Lordship.
Why this delay? Mr. Ghosh, this is not appreciated. When the court had passed this order on 22/10/2025, still the respondents are not responding. And that shows they have no care for what happens in the courts.
Lordship, apologies for that, but the thing is that.
Mr. A.K. Ghosh, learned standing counsel, Panchayat and Rural Development Department submits that the affidavit would be filed along with payment of the cost as ordered by this court-wide order dated 22/10/2025. Invariably on or before 31/7/2026. In the, should I now
No,
multiply it by 10, 30,000?
No,
Now we'll put it.
no, Lordship, while that's my assurance, it will be filed.
You will not.
Oh, it will be filed, Lordship.
It is provided that in the event the affidavit is not filed on or before 31/10/2026, the registry shall accept such affidavit only on the payment of amount of rupees 15,000 or above, along 15,000 along with the amount of rupees 3,000 already directed to be paid, deposited by this court-wide order dated 22/10/2025.
Lordship, that will be 31/7, 31/10.
31/7/2026. So that he will do.
Lordship, otherwise also these petitioners are all appointed before 1/4/1993, now covered by Sukendra Bhattacharya.
That a matter is pending before the division bench. I think it is there to move. So let us see what.
Lordship.
15,000 to that, yes. You file it, but last time I am giving you. 15,000.
Lordship, one instruction I have received. Lordship,
What?
for that
Yeah.
regarding the my lord payment of my lord areas salary loss. 3,28,613.
The first of heard Miss
F. Hussain.
F. Hussain, Learned Counsel for the petitioner. I can't put your name, so I just. Also heard Mr. J. Handick, Learned Standing Counsel, Revenue Department. Mr. Handick, on instructions received, has submitted that the area salaries claimed by the petitioner is admitted to by the respondents, and admitted to by the respondents. Also, it is further submitted that the petitioner is entitled to an amount of rupees 3,28,613 in this connection. Also, he submits that there be not be sufficient funds available for release of the said amount. The proposal could not be forwarded to the government for its necessary approval. He further submits that the proposal in respect of proposal for release of the area salaries, admitted area salaries of the petitioner shall be forwarded to the government in the Revenue and Disaster Management Department within a period of 1 month from today. So he submits that the approval being so granted, the amount involved would be deposited in the account of the petitioner within a further period of 1 month from 1 month thereafter. So, in view of the above development taking, in view of the above position, it is directed that the proposal with regard to release of salaries to the petitioner be forwarded to the government within a period of 1 month from today. The government shall thereafter approve the same within a period of 15 days thereafter. So, the government approval being received, the said amount would be credited to the account of the petitioner within a further period of 15 days thereafter. The respondent authorities shall strictly adhere to the timeline set out herein above by this court. Registered to list this matter again. On 25/9/2026, Mr. Handick, on the next date of listing, shall place on record documents envisaging deposit of the said amount in the account of the petition.
Actually, the petitioner is going to retire by 30th September, you know.
Yes, September, we have kept it on 24th. And if they delay it further, we'll give you interest. I told you that they will. I don't want to dispose it of, because dispose it of again, you will have to come back on contact.
Deeply obliged, Your Lordship.
25/9. 25/9.
Deeply obliged.
Further hearing for further hearing. Or was any against?
I got a part at with. So you can take up the 42 first, because in 42, my lord, my part I already concluded. It was for the response.
You
I can
will go
refresh.
by serially.
Okay, fine. my lord.
Hey, legal close over. What if? Do you think I remember all those things ever?
Lordship is taking up item 40.
Dipanjal Das.
Yes, my lord.
This is that MIT.
No, my lord.
No, this is that railway.
This is railway one.
Railway.
Lord, I have prepared.
Which one Lordship will be taking?
Actually,
Tezpur University PhD?
No,
No,
first
I'll-
will be NOC.
NOC.
NOC, then PhD. Oh, you want me to take the
Yeah,
other?
yes, let it be the other one.
Both are praying for who am I to stop. Okay, tell me.
Like this, briefly, my lord, refresh your lordships with the facts, my lord.
Is there any list of dates, something like that? Nothing.
But one I gave, list of books, I think I gave.
List of books is there, but where
Yes,
is the
list of dates, my lord, no, it's
Okay,
not there.
okay, proceed.
The petitioner initially joined NID on 23/9/2019 as senior engineer within bracket land building and maintenance. That your lordship will find page 30. Thereafter, my lord, Tezpur University issued a notification dated 10/3/2025. My lord, circulating the academic program for PhD, my lord.
Page
34. Now, the petitioner is interested in PhD in civil engineering. That my lord will find page 35.
serial number?
Serial number, my lord, after 3, PhD in second line civil engineering, my lord, last one. So he applied. He submitted his application on 4/4/2025. Then, my lord, 4/6/2025, a notification was issued, page 37, declaring the shortlisted candidates for written test, my lord. The following candidates are provisionally shortlisted to appear for written test stroke personal interview in physical mode, page 37. For admission into PhD program in civil engineering, Tezpur University, autumn 2025. Candidates are requested to bring the original and photocopies of all supporting documents for verification. Written test stroke personal interview on 19/6/2025. The name of the petitioner at serial number 6 in the list
Written
1.
test plus personal interview.
Yes.
Okay.
Name of the petitioner is at list 1, serial number 6, page 37. Then, my lord, page 39. In between, my lord, he took leave on page on 19/6, and he appeared in the exam on 19/6, page 39 are the results, my lord.
Now, when you took this leave, did you disclose before the authorities that you are?
The leave application doesn't say that it was simply a casual leave, my lord, for personal reasons. So page 39 is the, my lord, results. My name is at serial number 3 under the heading PhD in civil engineering. So I was provisionally selected. Then page 40, that is my communication dated 10/7, and my application in fact dated 10/7/2025. To the director, NID Assam, request to grant permission to pursue PhD in civil engineering autumn 2025 from Tezpur University. To the chief administrative officer, NID Assam. With reference to the above subject, this is to inform you that I am interested to pursue PhD in civil engineering from Tezpur University as per the published merit list for admission for autumn 2025. On completion of above mentioned program, I expect to have a better and deep understanding of the concepts of civil engineering, which may be utilized to perform my duties for the benefit of the institute in the field of practical civil engineering works. The admission process
The admission process starts from 10/7/2025 and ends on 14/7/2025. An academic session may commence from July 2025 and beginning of August 2025 tentative. I intend to pursue my PhD study on part-time basis. Therefore, it is requested to grant permission to pursue PhD in civil engineering from Tezpur University for further career development and enhancement of knowledge of the undersigned for performing his duties and efficiency. I have enclosed the merit list also below, in down below. Then they sat over it, my lord. The petitioner persuaded, but they did not respond. Last date of taking admission was 21/7/2025. So having no response, no alternative, my lord, he was constrained to take admission, my lord. And admission was given my lord, provisionally subject to submission of NOC.
Where do I get that? Is there any notice, anything with regard
There,
to
my lord,
that?
I'll just come to my lord. There is an email, my lord. I'll just show it. Then, my lord, page 41 is an email by the institute to me raising 3 queries, my lord. This email was dated 29/7/2025, my lord. With reference to your application dated 10/7/2025, that is my application for, my lord, permission. Requesting permission to pursue PhD program on part-time basis from Tezpur University autumn session so the competent authority has decided to seek explanation on the following. Reasons for not taking permission of the competent authority for repairing the test for pursuing PhD from Tezpur University, whether permission or permission of station leave for appearing in the said test for pursuing PhD was taken, reason for not completion of task like mutation of land, preparing estimate for repair works of the institute with DSR 2023. So they started raising this query. Then the petitioner responded to this query, page 42. His response were, during the time of application, no NOC was sought or any requirement to provide NOC was mentioned. However, the NOC has been sought only during the time of admission. Accordingly, request to issue NOC to pursue PhD at Tezpur University was submitted on 10/7/2025. Intimation regarding station leave was submitted prior to proceeding on leave. Task pertaining to mutation of land has already been completed and estimated cost amounting rupees so and so. Considering DSR 2023 rates as repair works has already been submitted.
Okay.
Hence, it is open. It is once again humbly requested to issue NOC to pursue PhD in civil engineering at Tezpur University so that an opportunity of enhancement of knowledge and further career development could be availed by the undersigned. This was his response. Then there is another application, another email. Sorry, Miller, this is the impugn order, page 43. They have issued this impugn order on 26 August. After their email, petitioners reply on 26/8/2025, they have issued this one-liner. Page 43.
Yes, then.
With reference to your application for pursuing PhD on part-time basis, your request has not been accepted by the competent authority for this time.
You can proceed. Then?
44. Then the petitioner, my lord, he submitted another email reiterating his prayer. Page 44.
For a reconsideration.
Yes. For reconsideration of the decision, my lord. Then the respondents, they again issued an email raising 3 more queries. This is dated 3/10/2025. Pursuant to your email reconsideration of your seeking reconsideration of a rejected application for pursuing PhD at Tezpur University on part-time basis, we would like to seek the following clarifications before placing the matter again before the competent authority for reconsideration. Number 1, as per UGC guideline, a minimum of 1 semester in-campus coursework is prescribed for PhD program. Please clarify whether this requirement is applicable in your case at Tezpur University, Tezpur, and if yes, how you can plan to pursue it either from Jorhat or Gauhati. Number two, please clarify the current status of your selection admission to the PhD program at Tezpur University. Please also clarify if NOC permission from NIT is a pre-qualification for PhD admission at Tezpur University. This was on 3rd October. Now, before I could submit my reply to this, they directly wrote to the Tezpur University. The institute directly wrote to the Tezpur University by an email dated 6/10/2025. And reply of that email, your lordship will find page 46.
Where is the, what was written?
My lord, what was written, it's not there, but in this 8 October 2025, the reference of 6 October is there, my lord. Their email to the TU. Page 46. This is in reference to your email dated, my lord, the answers will reflect the queries, my lord. This is in reference to your email dated October 6, 2025 regarding so-and-so admission status to the PhD program in the Department of Civil Engineering, Tezpur University. The point-wise information is as follows. Admission status, yes, Mr. So-and-so has taken admission to the PhD program of the Department of Civil Engineering on 21st July 2025. He has been provisionally admitted as he has not yet submitted his postgraduate original certificate, work experience certificate, and no objection certificate from his parent institute, NID Assam. Submission of NOC. No, Mr. Odhikari has not submitted the required NOC from NID Assam. As per the university's admission conditions, provisionally admitted students are required to submit all pending documents, including the NOC, by 31st October 2025. This was the date, my lord, in Lordship's query, my lord. UGC guidelines on coursework. Yes, the UGC guidelines prescribe in-campus coursework for a minimum of 1 semester are applicable to all the PhD candidates, including part-time and in-service students under the provisions of the regulations. So these are the queries to me also. Ultimately, they got the queries from the TU, my lord.
You did not reply to this email.
Before I could submit my reply, my lord, on 6th they have issued the email to Tezpur University, 8th they got the reply, my lord. Thereafter, show cause notice was issued, and my lord, on the same allegations, I'm not happy on those things now. Now I'll just take your lordship to page 66. Because they have issued a show cause notice incorporating these allegations that I did not submit application prior to appearing in the written examination, that culminated into a minor penalty, my lord. That is fine. But page 66. Notification by TU for enrolling in spring program, my lord. In response to that, my lord, the petitioner wrote, this is to inform you that I am yet to obtain the no objection certificate from my current employer, due to which I could not initiate the enrollment process for spring 2026. However, I shall complete the enrollment process as soon as I obtain the no objection certificate. It is humbly requested to allow me to extension of time to submit no objection certificate. Now, they have mentioned in their affidavit regarding my MTech. You know, this is my application, page 67, during my MTech. In BITS Pilani, my lord. Request to grant permission and consent to pursue MTech in environmental engineering from BITS Pilani under work integrated program. With reference to the above subject, this is to inform you that I am interested to pursue MTech in environmental engineering from BITS Pilani under their work integrated learning program, which is scheduled to begin from so and so. The entire duration of the program will be 2 years, and it will be conducted through online mode only. Since the program will be conducted through online mode during weekends, so enrollment in the course shall not hamper my involvement in the day-to-day activities of the institute and also not affect my job responsibility. So this was basically what online was the yes, my lord, in MTech. Now, page 68 are the PhD regulation, my lord.
of the Tenshpur University. Page 72, Lordship will find serial number D, the part-time thing of the curriculum.
72 part-time.
Part-time. Then the regulations say, page 76, my lord. Regarding NOC, my lord. The employed part-time candidate shall submit no objection certificate from their employers.
Where are you reading?
Page 76, my lord.
Employed,
Yes.
3.3.4.
3.3.4, my lord. The employed part-time candidates shall submit no objection certificate from their employer stating that the candidate shall be allowed to get themselves admitted to the PhD program if selected. Such candidate shall complete the coursework and submit the plan so and so by third semester after obtaining necessary leave in the prescribed format from their employers. So if selected, then only they are required to getting the course.
Can you give that meaning to this?
Sorry, my lord.
Can you give that meaning to this? That is not the meaning which is coming.
Even then, they never insisted, my lord.
With that as it may.
Yes.
What it says is employed part-time candidates shall submit a
No objection certificate from their employer stating that the candidate
stating that the candidates shall be allowed to get themselves admitted to the PhD course program if selected. So that is a prior requirement. Then if selected, they'll have to say that we will permit him to undergo
Lord,
that.
I can explain this, my lord. Although it has been, my lord, the formation of the sentence is like this, my lord. I have got their application, online application format. My lord, there is no column to enclose the NOC, my lord. I can produce the online application right now, my lord. It did not contain any column to.
Have you said something of this, any pleading?
No, my lord. It's not, but I have the online because it came in the. If your lordships considers this online application which I submitted, my lord, and even otherwise also, my lord, they never insisted for the NOC. They wanted NOC only at the time of my lord admission. Because it directly does not connect with my eligibility and qualification, my lord. It is only a, my lord, procedural formality that I am required to get the NOC so that I am not in two places at the same time.
Yes, next.
Then, my lord, after this, nothing happened. Then the petitioner approves your lordships, my lord. As per Rule 51 of the CCA, the petitioner is entitled for 24 months in his entire service life of study leave.
CCS leave rules.
Yes, my lord. CCS leave rules. Rule 51. 1972.
Rule 51.
Yes. Maximum amount of study leave. The maximum amount of study leave which may be granted to a government servant other than Central Health Service officer shall be ordinarily 12 months at any one time and during his entire service 24 months in all inclusive of similar kind of leave for study or training granted under any other rules.
So 12 months at one stretch, total
Yes, for
24.
total 24 months in my entire service career, my lord. At no point of time in an entire service career, my lord, I had availed any study leave, my lord. This is for the first time. I am praying for study leave. I am praying for study leave, and in fact, Rule 50 deals with conditions of study leave, my lord. Leave rule for Nasari. I have given the list of books, leave rules. CCS leave rules.
CCS.
So, Rule 50 is the guiding principle, my lord. Rule 51 is the amount of leave I can get is Rule 51, and Rule 50 is the conditions for grant of study leave. If I may read, my lord, Rule 50.
Rule 50.
50, my lord.
Yes.
Conditions for grant of study leave. Subject to conditions specified in this chapter, study leave may be granted to a government servant with due regard to the exigencies of the public service to enable him to undergo in or out of India a special course of study consisting of higher studies or specialized training in a professional or technical subject having a direct and close connection with the sphere of his duty. I'll pause here for a moment. I am basically BE in civil engineering, and I wanted to pursue PhD on civil engineering itself. Study leave may also be granted for a course of training or study tour in which a government servant may not attend a regular academic or semi-academic course if the course of training or study tour is certified to be of definite advantage to the government from the point of view of public interest or is related to sphere of his duties of the government servant. And number two, for the purpose of studies connected to the framework or background of public administration subject to the not connected, my lord, for studies which may not be closely directly connected to the work of the government servant, but which are capable of widening his mind in a manner likely to improve his abilities as a civil servant, to equip him better to collaborate with those employed in other branches of the public service. Note, application for study leave in cases falling under clause 3 shall be considered on merits of each case in consultation with the Department of so and so so and so. Number 3, my lord. Study leave shall not be granted unless it is certified by the authority competent to grant leave that the proposed course of study or training shall be of definite advantage from the point of view of the public interest. It is for the prosecution of studies in subject other than academic or literary subject, provided that an officer of the Indian economic that is not relevant. Next proviso is for medical officer.
Study leave.
Study leave.
For other things. Study
For,
leave shall
it's also not relevant, my lord. May be granted to a government. Yes, my lord. Sir, 5 also, my lord.
6.
I'll have to complete the provision.
6.
Study leave shall not be granted to a government servant with such frequency as to remove him from contract with his regular work or to cause cadre difficulties owing to his absence on leave. So these are the, my lord, legal provisions under which I can get a study leave or my study leave can be rejected or refused, my lord. Now, if your lordships kindly see the impugn order, so I completed the requisite years of service for being eligible to study leave, my lord. I am entitled for 24 months. The reasons, the conditions on which my leave can be rejected, lordship has seen in the rules. Lordship will kindly see the impugn order now.
One line order.
One line order. Fine, no. Then
what is the
affidavit? Your lordship will kindly see the reasons. First, para 3 of the affidavit. Para 3, they said one of the reasons for rejecting the candidate, because since the impugn order doesn't contain any reason, they have filed the affidavit containing reason. Now, para 3 of the affidavit says, my lord, no approval was taken before applying for PhD.
And for that purpose, my lord, they relied on an OM dated 28 to 1955.
Nineteen fifty?
1955. And that OM, your lordship, is at page 103. In para 3, they say that before applying for PhD, I should have taken the NOC. And they relied this OM. Let's see what this OM says, my lord. Page 103, my lord. Subject is joining of educational institutions by government servant outside normal office hours. Now, in between middle, my lord, line starts with ordinarily. Ordinarily, there can be no objection to the pursuit of knowledge by government servant in their leisure hours. But this must be subject to the condition that such pursuit does in no way detract from their efficiency. Wherever found necessary, the administrative authority may require that government servant under their control should take prior permission before joining the educational institution or course of studies for university degrees, as the joining of the educational institutions involves an advanced commitment about attendance at specific hours and absence from duty during the period of examination. So the OM provides that before joining the educational institution physically, you are required to take the NOC, my lord. And to buttress their point that I have to ask for NOC, I have to apply for NOC even prior to my submitting application, is not supported by this OM, my lord. This says before you join, then only you have to. Then they gave reference at para 6 of the affidavit. They gave reference to my previous MTech course in the year 2022. Para 6. That when petitioner was previously permitted to pursue MTech course in the year 2022, the work of the institute suffered, which can be seen from his APR gradings. Few examples of the predicament faced by the institute at that time are as follows. Some predicaments they have mentioned. Predicament number 1 to predicament number 11. There were some lapses on my part in the year 2022. Now, if your lordships kindly come to para 16 of the edition, this affidavit in opposition, they say that in para 6 that the work of the institute suffered, which can be seen from his APR gradings at para 6. Para 16, my lord, will kindly come. This is of 2022. Para 16, last 3 lines. Excellent in the year 2020. I'm sorry.
Then 93, yes.
Yes, excellent in the year 2021, 2022. So they themselves have said at para 6 that my which can be performance can be gathered from the ACRs of 2022, and my performance was excellent.
So this is 2020 to 22 is the period when you pursued your MTech course.
Yes. They themselves have said, pursued MTech course in the year 2022. Para 6.
Yes.
Then, my lord, para 7. Did not approach with clean hand. EOL applied on 24/9/2025 for 1 year. They say that on 24/9/2025, I applied for EOL. And my application for grant of NOC is 10/7/2025. Now they wanted to correlate these two things, that is my application for NOC vis-a-vis my application for UL, and project a case that how can I pursue two things together. But that UL was never granted, my lord. That never
Did
happened.
you remember, take UL for 1 year?
My lord, my mother expired.
That will not take you for 1 year.
No, I'm saying, Lord, he is the only son. His mother expired. His father is 80 years old. In fact, my UL application, they have annex, I have written all those things. His father is 80 years old with lots of health issues, my lord. My lord, basically, my lord, he was so, my lord, frustrated at that point of time. His mental condition was not that good. So he, at one point of time, he thought of like, my lord, just giving away the job also. So out of that, he applied for 1 year UL, but that 1 year UL was never granted to the petitioner, my lord. It never happened. So there is no question of correlating the both two events, my lord. Since it was never happened, how can you correlate? So I, in my reply, rejoinder affidavit, my lord, affidavit in reply para 7.
Okay.
I
Then what?
I dealt with all these things.
These are ancillary issues. very
Ancillary
trivial
issues.
thing.
My lord, on the affidavit, my lord, all the reasons they have cited, almost all are ancillary itself. Then para 8 also, same thing they have said, applied for UL 24/9/2025 and also appeared, appealed 1/10/2025. This is my second application for reconsideration. So they tried to project that simultaneously in the month of September and October. One is for UL, one is for PhD.
You mean to say that this was a coincidence?
It was a coincidence, my lord. And
Okay,
when
proceed,
the
proceed,
UL
proceed,
never
proceed.
happened,
Proceed.
yes, my lord. Then para 10, they said about 3 queries. No response from the petitioner. They say, I misled. You got the response from the Tezpur University. This I replied in my para 9, my lord.
Okay.
Then they say para 14. It is, my post is not a teaching or research post. Then para 29, they say no enforceable right created to compete to issue NOC. And lastly, para 31, my lord, 2 bullet points. For prior permission before joining, they themselves has said on this occasion, my lord. So my humble submission is that, my lord, neither from the impugn order nor for the affidavit in opposition, there is any legally justified reason that has come out to satisfy Rule 51, my lord.
Okay.
Nothing was there. So that's why on one occasion, I think, my lord, third last occasion, your lordships wanted to see what if there is something in the records. Now, what I'm on is, you know, I want only 6 months time as study leave, my lord. Even with not fall, my lord. You are a model employer, my lord. How you are to act in such a situation?
Yes, before we now leave this affidavit.
Yes,
Come back to page 60, para 16.
para 60
16.
of the 16 of the affidavit, madam. Yes, madam.
What is the grading in 25, 26 for you?
24, 25, 25,
26?
not 25, 26 grading, I don't have, Milord, I'll get the instruction,
Okay. Anything more?
Milord, that much, Milord, few judgments I have, Milord,
What are the judgments you are using? Royappa for
Milord,
Sri Lanka Vidyarthi, that reasons have to be.
exactly, Milord, my content, because one of the ground that has been urged by the respondents in many words is that I don't have any legal right for the leave.
Hmm.
That's a settled position of law.
You don't have.
I don't have a legal right. I cannot claim that you grant me leave.
But
I can only
you say
apply.
that their rejection has to be structured.
Exactly. So my contention is while relying
So Sri Lanka Vidyarthi for that purpose.
if your
Then the next one.
next one, this is basically to show what should be the attitude of the employer.
Ranjan Das.
Ranjan Das does not lay down any ratio.
That's what I said.
So, but I place Ranjan Das because of the fact that there was an order passed by the High Court granting study leave. So, Honorable Apex Court refused to interfere, upheld it. So, that basically
It
it's
was
not
on
a
the fact
ratio.
of that case. Nothing.
Exactly, it's not a ratio, Milord.
Hmm.
This is Quran. Then this Delhi High Court judgment.
So we ignore Ranjan Das.
I leave it to your lordships, Milord. Delhi High Court judgment I relied on because I should have got hold of the original Supreme Court judgment which has been relied on here in Delhi High Court. Rohit Kumar, State of NCT, Delhi. What happened, Milord? One doctor, he was not granted study leave because of the fact that COVID was going on at that point of time. But the seat he, Milord, got after an examination, it was precious to him, Milord. It's one-time opportunity. In that event, what the Honorable Supreme Court has held, para 21 of the Delhi High Court judgment, Milord. I'll give the Supreme Court judgment copy, Milord. Just for the sake of convenience, I'm referring to, Milord. That I to Dishune.
Just read. You can give me the copies. I have the list of books.
Yes.
Just give me the. Read what is.
This is only to show what should be the attitude of the employer towards his employees in such a situation wherein he is about to miss the bus. So para 20, Milord, at the same time, that will be page.
Para 21. Okay, got it.
Para 20, Milord. Para 21, wherein, Milord, the Rohit Kumar has been quoted and quoted portion, Milord. At the same time, this court cannot be oblivious to the legitimate expectation of COVID-19 variants like the appellant to fair treatment in conformity with the service rules by which they are governed to enable them to pursue higher education and enhance their educational qualifications. Needless to mention that the doctors with higher qualification and special knowledge and specific.
Okay.
Then, my lord.
Then Royappa?
In the Royappa para 87, with regard to legal right itself, I'll just read one paragraph. Para
Royappa has been thereafter discussed in many cases.
Yes, my lord.
It has been interpreted in.
But this para 86, my lord, vis-a-vis the legal right, I think, my lord, it comes to my risk because it was never my case that I have got a right. I am only on the point of judicial review. I am before your lordships to
We
exercise.
have to see whether the reasons are.
Number one, whether there are reasons or not, because from the pleadings.
We presume that there are reasons. And if those reasons are satisfying the conditions under 51 and 53 of the 51 of the leave rules.
Yes.
then fine, we will not interfere.
Correct.
But if we find that it is not within the parameters of 51, then we will have to interfere. That's what your case is.
Yes, my lord.
Okay.
And my lord, going by whatever has been placed as of now, we have seen, my lord,
We'll see, we'll see.
there is, my lord, this ROEPA, I'll just,
Okay, para 6.
86.
86, we got it.
Lordship will kindly go through it, my lord, somehow.
We'll read it, don't worry.
If required, I'll read, my lord, after my senior. So that is precisely my case, my lord. I only get only 6 months. I have served all through. This 6 months, I'll be able to get a PhD. Lord,
Yes.
that much only.
So I will start with paragraph 16 of the affidavit, but I'll go to the other paragraphs also. But let me start with paragraph 16, page 93. So Lordship has rightly seen his status,
Mr.
APR record.
We have already noticed that.
Yes, then Lordship will say, because my learned friend was very clear that his APR score was very good in the year 21-22. 21-22 was very good because till that time he did not pursue MTech.
No. He pursued MTech from 2020, 21 to 21, 22.
No, Lordship.
Yes.
From
MTech was-
22 he. Certificate he started in 22.
MTech in 22?
Yes. He pursued, his application is of 22. So after getting MTech, how his performance gradually declined. It was shown, the repetition of the 2020.
Can you give me the exact date?
I'll give Lordship. So 20 to 21 and 21-22, very good in the year. Then 22-23, good in the year, 22-23-24, and final 24-25, poor in the year. So now the present application is filed sometime in the month of July in 2025, when his record was poor in the year. So after procuring a very high degree, MTech, from BITS Pilani, his performance declined. So if we go by the mandate of Rule 50 of the Service Rule, Lordship, whatever higher course he pursues, it should be beneficial to the authority, to the department. So when we allowed him to pursue the MTech course from BITS Pilani in 2022, his position was quite good, but after obtaining that degree, his performance declined. Yes, page 88, Lordship, paragraph 6. The petitioner was previously permitted to pursue MTech course in the year 2022. This is his statement. Oh no, it is in our affidavit. In our affidavit. So we gave him the permission in 2022. So now, what is his role? What is his scope of duty? Page 30 of the writ petition.
Page 30 of the writ
petition. In his appointment order, this was quoted. Page 30.
Continuing in the entry cadre. You're continuing in the entry cadre. No promotion, nothing. Or it's a single cadre post?
A single cadre post, senior engineer.
It's a single cadre post.
So if he leaves the department, Lordship, the department will suffer immensely.
There is another post, my lord, which is above me. That is the post of, I'll just.
Senior engineer is a single cadre post, Mr.
Yes.
Surya.
Single cadre.
Then.
Okay, Mr. We'll see.
Yes. Deputy engineer electrical. Next. Higher post.
So electrical, that is a different branch.
So land building and maintenance, this is, you're a civil engineer.
Civil engineer.
Okay, then what happened? What
So
is the scope?
Page 30, serial number 5, appointment order issued on 23rd August 2019. What is his role and duty? As senior engineer within bracket land, building and maintenance, your task and responsibilities would include the following. Number one, A, overall supervision of building and maintenance services related matters.
2, coordination, supervision and processing of technical, administrative and financial matters relating to existing as well as new building construction projects of the campus. Supervision of routine carpentry work, drainage, plumbing, maintenance work, etc. and other allied works like cleaning, housekeeping, gardening, etc. being executed by the maintenance staff to prepare estimate, tender notice, scrutiny of tenders, recommendation of award of contract, etc. Checking and certifying of contractors' bills, measurements, as well as checking, certifying contract, etc. Extra item rates, deviation in quantity, etc. Coordination of drawing approval, water and drainage connection, electric power, etc. with the local authorities as and when required. Next, liaising with government agencies relating to land, building and maintenance matters, any other tasks as assigned by the senior authorities of the institute. So these are his scope of work. So for this work, whether PhD in civil engineering is necessary or not, it is the core issue before the authority.
Mr. Soikia, just an interaction here. Whether it is your projection that for this job, he does not require a PhD.
That is one. And number 2, his performance is very poor now.
So, say we hold
Yes.
that he hold, or means not the court, any court holds that
yes,
the degree is beneficial to him.
Yes.
Let's hold. So you are ready to spare him then?
Yes.
If a situation comes.
That is why, Lordship, I'll just let him dekha
Mr. Soikia, you have not got me. What I'm
Then I got it. If it is beneficial to his duty.
No, if it is only your case that
there are multiple reasons. One reason is this also.
What would be the other reason?
Other reasons is that he has violated the service rules and conditions.
That is true.
Number 2.
Now, what is the third?
Number 3, there is no substitute. That is no substitute.
That is what I want.
And although.
So is that a ground taken by?
Yes, all these are part of the deliberations.
Where is the decision?
I have placed it. Lordship may be pleased to peruse it, or if Lordship wants, we can file it in the form of an additional affidavit also. It may be required, Lordship, to file it in the form of an affidavit also. But one more thing, Lordship, before I continue my arguments, whether this case is still alive or not. 30th October was the last date.
Mr.
One post may be kept vacant, but whether.
It's not that. They have now autumn season is gone. Spring has come. No, what is that?
It is only 1 year has gone.
Autumn is
Autumn, fall, everything gone.
That's why. First point. See, I'm a man who, this court is one who tries to finish up matters on Fisher.
No, that is what.
Immediately I caught up Mr. Chaudhary, RKD Chaudhary, appearing for Testpool. He said that admissions would be permissible. There will be a notice issued now in the last week of July.
Right.
Therein he can take permission. That's why I did not post it with him.
That I am not. I was not aware of that.
Mr. Chamua was here. So that issue will
already dealt with. No fight.
So Mr. Soikia, from this show me that you are not in a position to release him because of the exigencies of
various reasons. Lordship, I'll come one by one. First is that, Lordship, there is a violation of the notification that before initiating any admission process, he should inform the department and he should take the permission. Because ultimately what Tezpur University says, that is not relevant to the department. What the departmental rules and regulations say, that is mandatory and applicable to the authorities while taking a decision whether a person should be given study leave or not. For that, Lordship will kindly come to paragraph 3 of my affidavit.
No, I have the soul now with me.
Yes.
From this soul you show me.
I don't.
You have a copy?
Second copy.
You can give me a photocopy. I don't want this original.
Lordship.
We can. This is not the original. We can make marking.
No, Lordship, I have.
Yes, Lordship will kindly come to note number 16. Previously, when Adhikari number 2, second page, Adhikari was permitted to pursue MTech during 22-24. It was observed that his productivity in office had lowered considerably and is reflected well in his APR, so much so that he failed to comply orders, did not complete assignments such as mutation of lands, preparing estimates for repair works of the institute with DSR 2023. Further, it is the prerogative of the institute to give permission or not, taking into consideration the need and interests of the institute. Permitting Adhikari to pursue PhD does not serve the interests of the institute, therefore the permission is not recommended. Very categorical, Lordship.
No, where is that ground that you have now projected that releasing him would not be in the
It is not to the interest.
Where do I get it?
No.
His pursuing the MTech did not benefit you, I understood.
Yes.
That is there.
That is sufficient to comply with the mandate of section.
But one more very emphatic thing has been
That
taken.
is why, if Lordship is pleased to look at the impugned order, let us come to the impugned order once. Let us come once, because it is not properly languaged or structured. That is the submission by the other side, and Lordship also agreed to that. But let me place it from our perspective.
No, I did not agree. I only said that it does not reveal the reasons.
No, it will. Let me make it from our perspective. What is the meaning of that order?
That is page
R3 in our affidavit 106.
106. Okay.
With reference to your application for pursuing PhD on part-time basis, your request has not been accepted by the competent authority for this time. What is the meaning of this for this time?
Only that rejection is not permanent, but presently you are not giving it to him.
Presently we are not giving, because if you show what are the areas where there is a huge shortfall of service, we are not shutting the doors permanently. Suppose there is a second post for senior engineer tomorrow. It will be very easy for us to give also. But at the same time, we have to also consider whether his PhD is required for his service or not. That is a paramount consideration of the department. So this is for this time. So in future, it may be open subject to the prevailing conditions at that relevant point of time. So now let us place my case from the affidavit. এখন তোমার ফোন না So Lordship will kindly come to page 86 of my affidavit, paragraph 3. Before embarking on
just a moment, Mr.
Lord. Okay, point. Prohibitions during the intimation.
You can come to note 20.
20 is very clear, detailed is
Last. That's what I was.
Yes.
saying.
May I read it, Lordship?
No, it's okay, Mr. It's okay, I've got
This is very detailed. Everything is.
Have you given a copy to Mr. Das?
That is why that affidavit may be. Suppose Lordship judgment is based on these notings.
No, no.
The other side will not have an opportunity. I am talking from a different perspective. As an officer of this court,
is there any notice?
I am on the other side also.
Is there any notice till date issued by the Tezpur University?
Yes,
When?
recently.
What is the last date?
24th July. Because my previous admission goes, my lord, I'll have to again take admission and I'll have to take admission according to this notice itself. এখন দাদা নতুন যোনটো পৰীক্ষা দিব নালাগে এডমিশন আকৌ ল'ব লাগিব
পইচাটো যাব
পইচাটো যাব মানে আৰু প্ৰচেছ মোৰ আগৰটো কেণ্ডিডেটটো আছে হেৰিটো এডমিশন ফিজটো টাইপ আউট হৈ গৈছে
24th is Friday.
Friday, my lord.
Mr. Soikia. Mr. Das.
Yes,
Mr. Soikia has produced the records
Yes, my lord.
wherein the reasons are given.
Fine, my lord.
Now, Mr. Soikia is fair in saying that an affidavit should be filed because
Fine,
naturally he's thinking from your point of view.
fine, my lord.
But if you consent that no affidavit is required, we can take up this matter by pursuing the thing, then we can proceed.
My lord, may I just have a look of note 20, my lord, what has been said?
Note 20, this court will require your answer only with regard to the penultimate paragraph.
In
Other things,
further, as per UGC
You give up.
guidelines, the presence in the station of the university during the coursework one semester is mandatory, and as the test period far of Jorhat, far from Jorhat, station leave on nearly 6 months would require to, so which invariably would affect the institute work.
works.
And also
So,
from his
If
previous.
that is
record-
the perception of the authorities,
Yes,
and given the nature of your work,
yes.
how can this court sit over appeal on that? The other submissions, with due respect to Mr. Saikia, maybe we are not accepting for the time being. But this reason, which he had also urged, how can we close our eyes to that?
Look,
Because your personal interest cannot be at the cost of the interest of the university.
instantaneously, my lord,
You are not in
we
a position.
somehow.
So what we do is, it's
No, no,
already
one second,
put a tick.
one second. There is an office memorandum issued by the NID itself. My lord will kindly.
That is
have-
why in the affidavit, he can reply.
No, I'm just, since your lordship has.
Become
one-
infructuous.
Lord, I preempted this question, perhaps it may come because I didn't, there is an office memorandum issued by 2022. It says, in the interest of the institute to ensure smooth functioning, the competent authority NID Assam has been pleased to assign the charge of the estate section to the senior most staff of the estate section in the absence of senior engineer. Therefore, as per the present order of seniority, Sri so-and-so, Deputy Engineer Electrical shall be in charge of the routine work at the estate section till resumption of duties by the senior manager. He shall be responsible for all estate activities and routine maintenance and repair works in the so-and-so, so-and-so.
See, this
There is already an
this is-
alternative arrangement.
This is nothing. This is something which they'll have to, this we cannot ask them to do.
No, they have done it already.
They have done it. They may not do it. It may not be for 6 months. It might be for a small, short duration when you
No.
had for a few days gone somewhere.
No, they say,
You had taken a leave. But for 6 months, keeping you away may not be proper. So that is again a issue. Whether your degree, PhD degree, why is see an advocate does, what is a PhD degree for? That day also I said, I had asked Mr. Chomo.
obviously enhance my knowledge. and-
PhD degree is opening your minds.
Correct.
You get, because the research that you do, you get a
Goes to
lot of
different
opportunity.
horizon.
So an advocate, LLB is more than enough. But persons go ahead and do the LLM, then what do you call that, PhD. By doing that PhD, it's not benefiting them in a practice. Practice is not going up.
My friend will object.
No.
Lordship and me will agree.
Agree. No, the practice is not, no, Mr. Soikia, let me not be caught wrong. The practice is not increasing, But the
I
approach,
fully agree, Lordship.
approach will differ.
Their perspective, their mindset will open
Mindset
up.
changes.
They will get exposure to various angles.
Angle. So Mr. Chamoha is getting a
And
exposure.
Dr.
different-
B. Gogoi also. Vivek Gogoi.
Vivek also. So thing is that's why Mr. Soike, I was not very receptive to your submission that it's not related to the
No,
job. It's not-
these some judgments has helped me. That's those judgments I am going to place little later. Lord.
So today may not possible, we'll pass the orders tomorrow. You place your judgments in the first half because it's already 4:30.
The affidavit, additional affidavit, should I file?
He has not denied.
No, he has not denied. Lordship, the problem is that suppose it goes against him in before the division bench, if he appears okay,
I will.
another advocate will come and say that we
Mr.
did not
Soike-
get the
Mr.
opportunity to
Soike,
counter this.
Can you file the affidavit by Friday?
By tomorrow, I will file it.
Tomorrow.
By tomorrow, we'll file it. We'll just bring this on record. Even nahi. Oh, the
But
flood
today
is there.
flood is-
Otherwise, only
The
I
advocate
just
clerk can file it on his behalf. You can swear it by the advocate clerk.
that I'm not very of the procedure.
Okay, fine.
Otherwise, because this will be very much relevant, Lordship, at a later point.
Because thing is, rightly, wrongly, the last date, classes start on 29/7/2026. Last date for admission is 24.
No, we'll get it done, Lordship. By email or department. He will do something, Lordship. Up to Jorhat, I think there is no difficulty over flood.
Jurat, beyond Jurat only. Tomorrow
No,
we'll-
They will
So
do it.
on
Lordship.
this
It is-
aspect,
Hmm.
now you know what it is. The additional. the
They only
affidavit-
say very vaguely that it will cause
No,
inconvenience.
Mr. Thus, it's not vague. There is an assertion made. This is what was troubling me, whether it is there or not. Now that when they come to a conclusion that my service, my work would suffer, it's a reason which is germane considering the fact that you are a single employee there. And your appointment order itself sets out what you have to do. Be that as it may, you apply your mind, we will have it at 2 o'clock tomorrow. Mr. Soike, or I keep it open, subject to your convenience.
Lordship.
Bringing this on record.
We'll bring it on.
So what are the decisions you are trying to?
I'll
Do one thing.
My
Write
whole
down the
argument,
paras.
Lordship, I have prepared a written argument, I'll place it.
Yes, please.
It has the judgments, everything is there.
Oh, it's there. Just give me the copies there.
Yes.
Copy is also ready if Lordship wants.
Wants to means who will give me otherwise? And you also give me us that.
Yes, will.
Documents.
Yes, yes. I'll give me.
I have it in my.
Well, I will. One is.
Okay. I'll hear you for 5-10 minutes tomorrow if required, then we proceed. to
Lots.
dictate.
Fine.
The other one can wait. Other one, that.
Other one, some
I
other.
will-
That is the NOC.
That is not a parted matter, tied up matter.
Oh, no, it
That
was.
is not a tied up matter.
My lord. It is, I think it has come by virtue of the roster.
Roster, okay.
Yes.
So that
Uh,
may come up
okay.
next week, Lordship.
That will be. Heard deal on a council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again tomorrow for admissions. Also, এই কাম এটা কৰিবা এইটো আহি যাব কালি এইটোতো হৈ যাব প্ৰব্লেম নাই এইটো যিটো শুনি আছো আমাৰ এইটো বাই স্লিপ কৰি ফাইলটো মোক দি দিবা আৰু নেক্সট কোনটো আছিল এটা থাকি গ'ল যে 40 40 লিখিবা as agreed to by the learned council for the parties but Mr. H.K. Das, learned counsel for the petitioner, also Mr. D. Saikya, learned senior counsel, assisted by Mr. A. Sharma, learned counsel appearing for the IOCL authorities, and Mr. D.J. Das, learned CGC, appearing for the railway authorities. So, as agreed to by the learned counsel for the parties, registry to list this matter again on
The other case, Lordship. Let it be on Wednesday next, Lordship.
Wednesday. The Wednesday, Tariq to delivery.
It will be 29th.
29.
Staple my river. What is?
There is an interim order in the other matter.
Which one?
In item 40.
40. A second to the interim order passed earlier to continue till the next day progressing. That one is a way to know.
In this matter also, there is an interim order. In the present matter also, there is an. interim
Just
order.
get the facts recorded, otherwise tomorrow it will not be possible.
Affidavit that I am required to file, I may be allowed to file across the.
Oh, you file it in the registry, give me a copy.
Well,
Why create problems when there is no problem?
That is the problem with doctorate law. Yes.
We don't have that problem. Mr. Sharma is also not having that problem.
Yes, yes, definitely not.
they are free from problems.
So you mean to say that we are creators of problems?
Maybe.
Okay, thank you.
Highly obliged.
Obliged.
It will I give all of dealing to this.